My lord,
Yes, call the list.
may I be permitted?
Mentioning tomorrow, please come tomorrow. Yes.
My lord, day after tomorrow is the date fixed, and
Please come tomorrow.
upon imposing cost adjourning the matter.
Come tomorrow.
24th was the last date, and again 6th has been
I
fixed.
did not mention earlier.
My lord, order was not been uploaded. I have annexed the orders.
My lord, my revisional application will become infructuous, my lord.
Why?
My lord, the urgency, my lord, that my lord, temporary injunction was granted, my lord, restraining.
You cannot wait till tomorrow.
My lord, the construction has been started, my lord.
I'm asking you cannot wait till tomorrow.
So it is item number 109, my lord.
I'm asking you, can you not wait till tomorrow? For
Very well.
mentioning for upgradation.
Very well.
My date has been
Madam,
fixed
for
on the day
If
after.
you mention every day, then the matters cannot be taken up. Please cooperate.
lord,
The court
kindly-
have fixed a date. Please come tomorrow. Don't mention any matter unless you can wait till tomorrow.
My lord,
Very well.
day after tomorrow is the date fixed. I have annexed the order sheet. 24th was the last date, and 6th was again fixed as last chance. Upon imposing cost, my trial court adjourning the matter, my lord.
You cannot wait till tomorrow.
Correction, my lord. Correction. Just
Hand over this.
Much obliged, my lord.
for inclusion, my lord, the earlier.
Please come tomorrow. Yes, call the list.
Item number 1, I am for the petitioner. This has come at my instance, my, for release of the matter.
My lord, I am appearing in this matter on behalf of the respondent, my lord. It was not noted. I have no notice over there in this matter.
Since I'm not inclined to take up this matter on personal, ground, this matter. Call the-
Lordship, 3 and 4. Same petition. I am not placing it. It's an instruction of petition. Two matters. 3 and 4.
Ashun. You are the advocate on record.
My lord, my lord.
The learned advocate on record of
I'm not on the record.
I perceive I appear for the petitioner. Well, there is some mistake in my lord the ordering portion. First of all, kindly see the item 5. The Ashok Sarkar has been printed. Well, the Ashok Sarkar, not Sardar. That is first mistake in the cause list.
Ashok.
Sarkar, not Sardar. Cause list, kindly see the Ashok Sarkar, not Sardar.
But
That
the
is
order it is
next, my lord, I appear for the on the part of the defendant, not the plaintiff. I appear for the plaintiff, not the defendant.
Which page?
My lord, that is the first page. That is your lordship's observation. Third line. The
That's the
constitution
instance of the defendant.
And
It should be plaintiff.
it is to be plaintiff. And another mistake in my part, in my petition also, that I have made mistake.
Sir, please come to your.
I am tell you,
So-
lordship, that is, it is first. Secondly, my lord, the 28th February, this is wrongly, my lord, typed. It is 28th November. It is, my lord, I have rightly done in my petition. 28th November, kindly see ordering in.
Yes.
And third point, my lord, the kindly come to page 2. The opposite party is not nine, what is the opposite party number one? Learned advocate appearing for the petition submits the suit property joint property. Opposite party number one here in transferring the portion of the suit property to the third
It
party.
should be
Opposite party number one, not all opposite parties. Opposite party number,
which page?
that is page 2.
Page 2,
Opposite parties, not, it is, should be opposite party. Opposite party number 1.
which paragraph?
That
Page-
is my second paragraph.
Second paragraph.
Learned advocate appearing for the petitioner submits that suit property is joint property and the opposite parties.
It should be opposite party
Party
number
number
1.
1.
Alright.
And my lord, the next paragraph, kindly last line, decimals of the out of 63 decimals plot number such as to the plaintiff note, it is by the opposite party number 1 by virtue of the deed of gift.
Opposite party number 1 is
One.
not the plaintiff.
Not. Opposite party number 1 is the plaintiff.
So I have said to the
That,
plaintiff,
I ask for my lord, the opposite party should be
plaintiff that is
that this is
Ashok.
my lord, correction.
as prayed for by the learned advocate for the petitioner. Leave is granted to
And for the petition, item number 7, kindly short pass over.
You are the advocate on record.
No, my lord.
Who is the advocate on record?
I don't know, but
An adjournment has been prayed for on the ground of the learned advocate for the petitioner. To stop, in view.
Sorry.
Yes,
Sorry, my lord, I left my glass in my car.
yes.
The interim injunction was refused by the trial court.
Yes,
And my lord, after that, my lord, the situation and facts had already been changed. But after 1 year, my lord, the appeal court granted injunction. My lord, kindly, তোমার চশমা একটু দেবে? আরে আমি চশমা
yes.
Lord, kindly come to page 94, the order passed by the trial court.
Page 94.
94.
Yes. Where is your plaint?
Plaintiff, my lord, at page 17. Lord, I was the defendant in the suit.
Yes.
Page 17 is the plaintiff.
Yes. You are the defendant.
My lord. My lord, what's happened, my lord, in pursuant to the agreement, my lord, in the year 2008, 144 square feet had been granted to the plaintiff as leave and license. And my lord, after 2 years, my lord, another agreement was executed, which was extended the earlier terms in respect of only 50 square feet of one room only, my lord. And my lord, after that, my lord, the plaintiff vacated my room. And in 2021, when I went to,
Vacated the room.
yes, my lord,
What is the document you have that the plaintiff vacated the room?
yes, my lord, from the plaintiff failed to prove or failed to produce any documents of his possession.
No.
My
You
lord,
said that you have inducted him by way of an agreement. Where is that agreement? Show me that agreement.
yes, yes. My lord, kindly come to page 28 first.
Yes. Please, page 28.
Page 28.
Yes.
This is the first agreement, my lord.
Yes.
And my lord, kindly come to
Can it be said to be an agreement of license or it is an agreement of tenancy?
not tenancy.
How do you say so? This is
Look.
to be construed.
My lord, the trial court will decide it.
Where is the judgment in the case of Achinto Kumar Shah, 2004 Supreme Court cases?
It is not with me, my lord.
So, the first paragraph of the agreement shows that it is to be construed as a tenancy.
Yes, my lord, kindly come to. My lord, kindly-
Licensor has been described as heirs, executors, representatives, and assigns. The concept of license is it's terminated only after the death. It cannot devolve upon. It is not a heritable right. This shows. If you want, I can give my prima facie observations on this agreement.
No, my lord, I am coming to that. I am coming to that.
So by this agreement, he was inducted.
Inducted.
Yes.
And my lord,
Page
kindly,
32,
No.
that was extended.
no, kindly have a look into page 30 first.
30, yes.
Page 30,
Yes.
12 into 12, 144 square feet.
Yes, yes.
Yeah. Kindly come to page 32.
32, yes.
My lord, kindly.
Caption of the agreement. Read loudly caption of the
Yes,
agreement.
lord. I got your lordship's point, my lord. I
No,
understand.
no, please read loudly. Caption of that agreement.
This agreement to lease,
Extension of agreement to lease.
yes, the headline. Headline. And kindly come.
Next is also this agreement to lease.
Yes.
So you have captioned this as a lease.
Yes. Yes.
So you cannot
I am on the.
evict him without due process of law.
Yes, yes. I am not on that issue, my lord. I am on the separate issue. Kindly have a look into page 32.
Yes.
And whereas lesser is the absolute owner of premises,
Yes, yes.
50 square feet.
Yes.
Lord, page 28, the agreement was for 144 square feet.
Yes,
Now it is extended only in respect of 50 square feet.
yes.
My lord, kindly come. to-
Other portion it is continuing by virtue of the first agreement.
No, what's happened, my lord? The existence of the property is not there.
Please show me a document that he has surrendered possession.
Yes.
That is your case. Where is the document?
My lord, kindly I will look into my letter.
Your letter.
Yes,
Show me. Your letter.
it starts from, my lord, page 84.
Yes.
Sorry, my lord, page 83.
Yes, 83.
3 rent receipts are there only. 6th of April 2019,
This is also rent receipt.
rent receipt.
So you have described this as rent.
Yes, my lord. Kindly. 6th April 2019.
So 2019.
2019. After the 7th of June 2019. After expiry of extended period, when he vacated, again he came back, and but he had been inducted only for 3 months, and that rent bill is annexed with the plan.
Prove it, Mr. Dolapati, in the suit.
Yes, I will prove it.
You
But
prove it.
my lord,
So you cannot, Mr. Dolapati, if he has vacated, you are not affected by this order. Kindly come to the appellate court's order.
yes,
Directed not to evict. If he is out, you are not affected by this.
no, my lord,
I will record your submission that is not out, so you cannot be affected by this.
what I want to canvass before your lordship, there is no building or premises at all. This is the vacant land after filing the suit. My lord, kindly have a look into the documents of the.
Mr. Dolapati, I am
AMC.
expediting the suit. I am expediting the suit. Have you
Yes,
filed your
I
written
have no
statement?
problem.
But this-
But my lord, the injunction should be vacated.
No.
Because my lord, my plan had already been sanctioned.
Mr. Dolapati, he is not there. You are not affected.
My lord, your lordship knows very well, my lord. At least I learned, my lord. After changing circumstances, when there is the loss, subsequent event during pendency of the lease, my lord, the fact had already been changed. There is no possibility, or there is no question to grant injunction over that suit property, because the existence of suit property is not there at all.
Mr. Dolapati, if you want, I will direct you to serve because no stay can be granted on this.
Yes,
Injunction order, no stay can be granted.
because the injunction, but the stay should be granted on the order of the appellate court.
Henry Gautam Kumar Hada, ILR 1994
Lord,
Calcutta.
I will bring those judgment on next day, my lord. My lord, kindly I will look into what is the order passed by the trial.
You can expedite your suit. There is nothing in
My
it.
lord, kindly expedite it, and kindly I will look into the order passed by the trial court, my lord. It will be great injustice to me because, my lord, the building had already been demolished. The new plan had already been sanctioned. Your lordship knows very well, better than me.
Show me that you have submitted that the plan was submitted. It's a vacant land.
Vacant
Before
land.
the appellate court.
Yes,
Show
yes,
me.
in my pleadings.
No, show me before the appellate court you have raised those issues. Show me.
Because the appellate court did not even call for the lower court record. Passed the order.
Not necessary, Mr. Dolapati.
Let the trial
Court
court
records in an appeal against an order of injunction. Only 3 documents are necessary: plaint, injunction, objection. Nothing more.
Yes.
Lower court records are not
My lord, on
necessary.
the trial code, I submitted a
Mechanically, lower court records are being called. That process is going to be stopped very soon.
My lord, I invite your lordship attention.
It is
Kindly
going
have
to
a
be
look
stopped
into
very
the
soon.
order of
So-
the appellate court. This is completely perverse order passed by the appellate court.
Show me the perversity.
Yes, my lord.
Yes.
Kindly have a look into first 94 page. That
Yes.
what trial court, the findings of the trial court, my lord, at page 97, my lord, paragraph 13. Page 97, paragraph 13, my lord. In the light of the above discussion, no irreparable injury will occur to plaintiff if injunction is not granted. Grant of injunction would involve more
Have you
injustice.
brought Oil Chatterjee's judgment? That was referred to. I appeared in that matter. Bring that judgment. This supports the case.
My lord, I bring at least 10 judgments, my lord. If your lordship allow me, then I can.
On Chatterjee, the trial just said it is not applicable. It squarely applies. I appeared in that matter. On Chatterjee versus Future Technologies.
I read this judgment.
So the trial court said it is cannot be applied. It squarely applies to the facts.
My lord, there is no prima facie case at all. The trial court observation of the trial court is there.
Sir, no state. By the order impugned, I will record my submission why I am not granting stay. I will record that. If you can bring in the meantime, ILR 1994 Calcutta, read that.
I will
It will be
bring, my
clear.
lord, kindly
And-
consider one judgment, my lord.
Judgment followed.
AIR 2000.
That
my lord.
judgment followed in Mubassar Hossain's case. Bring all those judgments. I think 2006 CHN
তো
also.
বললে তো আমি গুলিয়ে ফেলবো।
By the order impugned,
AIR
the,
2000 to kindly have a look into one judgment only.
then I will dispose of the appeal.
2002.
Because show that
2002 Supreme
then-
Court.
No, if you want to argue it finally, well and good, then I will take it up. Then don't say service.
No, kindly grant the stay of the,
Mr. Dolopati, kindly go through those judgments. Stay cannot be granted. It will have the effect of allying the. That is why I'm saying while refusing, I will record results.
my lord, I am
By the order impugned.
my lord, I am asking myself one thing which I learned, my lord, from the chamber. My lord, when the prima facie case or the three conditions of the injunction is not considered by the appeal court but granted injunction, when the trial court refused the same, the plaintiff failed to prove any prima facie case before the trial court. That is why injunction was rejected. And my lord, the premise, the schedule property is changed, completely changed. Now there is the vacant land is lying. Kindly consider this. And I am relying upon, my lord, AIR 2002 Supreme Court.
Give me the judgment.
Only there are two paragraphs, 10 and 11, my lord, I will place.
Fast. Motion being fast.
1649
AIR?
AIR 2002 Supreme Court,
Yes.
page 1649, my lord.
1649.
49.
Yes.
My lord, paragraph 10 and 11.
10 and 11.
Yes, only these two paragraphs.
For what proposition?
My lord, the yes.
This is with regard to election matter.
My lord, the proposition is when the facts lost its relevancy, then no injunction.
You have raised that point before the appellate court.
Kindly consider this document. Now it is vacant land.
No. Was it
The
placed,
corporation document.
Mr. Dolopati, was it placed before the appellate court? Show me that you have raised that point. Don't place new documents before the
Yes,
revision.
my lord, in my argument, it had been raised. And before the trial.
But it was not taken note of.
Yes.
Then you apply for review. Apply for review.
Kindly set aside it and
No.
send it back.
That is not the law. You have to apply for review. Not by setting, and I'm not remanding. You have to apply for review. I will record your submission that the submissions made by you were not taken note of by the appellate court. I will give you liberty to file an application
My
for
lord,
review.
Kindly consider
I
another
think
aspect. I will
82
tell
or
only
81 Supreme
30
Court.
seconds time, my lord. When, my lord, the plaintiff came.
Dolopati, I follow your argument. You have made submissions before the first appellate court that situation has changed
Yes.
subsequent, but that was not taken note of.
Yes.
Asul, this by the order impugned,
করলে আমাদের মনে থাকে।
Yes,
Defendant is the petitioner of your lordship. This is for expeditious disposal of this suit. My lord, I am suffering the injunction. Initially, my lord, suit was filed in 2019. Subsequently, it has been transferred and my lord renumbered of 2022. My lord,
order number 41 is under challenge.
no, my lord, I have prayed for expeditious disposal. The plaintiffs are repeatedly.
Kindly come to order number 41. The
41.
learned advocate for the plaintiff prayed for time, stating that he would prefer an appeal with respect to order number 40, dated 7th of December 2024. Kindly come to order number 40.
Yes.
So the evidence of the plaintiff was closed.
No.
Any civil division filed, Mr. Mahato?
My lord, my instruction, I have not. I have lodged a caveat, but no copy has been served.
That will be the difficulty, but if a civil division is filed challenging that, because kindly consider the right of a party has been closed. If now the expeditious hearing is passed, then
Then, my lord, may I pray
Perhaps-
one thing? Kindly allow me to serve a copy upon the plaintiff. Let them submit whether they have challenged or not. All right, my lord, I shall serve upon the plaintiffs.
Ashun. This application under Article
Well, if your lordships kindly give a particular
if you
date.
serve it earlier, they might come.
Yes.
That is why purposely I have
But
kept it
what
with
I
the
am
monthly
praying,
list.
what I am praying, my lord, instead of monthly list, my lord, if it is in the monthly list, it will be at the bottom.
Let it
Kindly-
appear first, Mr. Mahato. Then
If it is in a particular date,
they might come and you will get your chance earlier.
I am.
Yes, next.
My lord, I appear for the petitioner, my lord. Lord, I am appearing on behalf of opposite party. Mr. Anirban Rai is appearing in this matter, my lord, senior advocate, my lord.
Yes.
For personal ground, my lord, is not come today, my lord. Plus, not today, my lord. My lord, I don't come in the way, my lord. But my lord, there is another application in the same, my lord, a connected application, my lord, that can be tagged in the monthly list, my lord. Connected CO, but that can be tagged with this because in that application we have challenged the substantial order, my lord. This is a subsequent order.
It's
My lord.
appearing in the monthly list.
Yes, my lord.
Which item?
Item number one.
The learned advocate appearing for the petitioner submits that
11, I beg to appear on behalf of the petitioner, my petitioner plaintiff. My lord, the petitioner being the plaintiff, my lord, filed a suit for declaration and correction of dag numbers, my lord, before the learned third Munsif Court at Baruipur.
Is there any difficulty on my part to take up this matter?
My lord, I don't know that.
Since I'm not inclined to take up this matter.
My lord, I am for the petitioner.
Yes.
But I am against an order, my lord, which is appealable in the first blush. My lord, it is. Let's I disclose that. But my lord, there is a jurisdictional error. But this order, my lord, may I just?
Any jurisdictional error, please challenge that.
My lord, may I just please, I'll take 2 minutes, my lord. My lord, here, my lord.
I appreciate your submission that the availability of a statutory remedy by way of an appeal does not bar the jurisdiction under Article 227. That will be your submission.
My lord, my lord, I'll just, my lord, otherwise, why I say, my lord, this, I am against a demolition or an order which is restraining a demolition, which was at my instant pursuant to High Court's order and has been tested in statutory appeal twice over and affirmed. My lord, as some emissary comes, files a suit.
So this order was passed in a suit.
My lord, it was passed in a suit.
Please prefer a miscellaneous appeal.
My lord will kindly see, my lord, the abuse of process, my lord. My lord will see the abuse. My lord, there's a statutory bar, my lord. There's a statutory bar here, my lord. It says 408. My lord will kindly have a look at this section, my lord. Will kindly have a look at this. There's a statutory bar, my lord. My lord,
What is the statutory bar?
my lord, see, my lord, there's an immunity. My lord, 408.
Yes, no suit will be maintainable.
My lord.
Take that point. Can you not take that point in the miscellaneous appeal?
My lord, I can, my
So-
lord, I can, my lord, I can, my lord, but my lord understands, my lord, if this is permitted, my lord, some emissary, and my lord, this order, my lord, the demolition order is after thrice over, my lord, High Court has, pursuant to High Court's order, tested in statutory appeal, affirmed.
Sir, there is a decision of the Honorable Supreme Court considering the bar, the appellate remedy under other statutes and the appellate remedy under the Civil Procedure Code, wherein it has been held that the Article 220's challenge under Article 226 and 227 is a near absolute bar. You have not brought
My
that
lord,
judgment. Have you gone through that
I'm
judgment?
conscious, my lord, I'm conscious, my lord, but
Who is the author of that judgment?
my lord, I'll just check, my lord, I was.
You have
My lord,
said you have
my lord,
gone through that
my
judgment.
lord, I'm conscious of the law. My lord, I'm
Don't know who is the author of that judgment.
My lord, I'm conscious of the law. My lord, my lord, despite that, my lord, that's why I opened my submission.
Take all points in the miscellaneous appeal. Ashun. for?
My lord, the
Can one of
my lord,
20,
because I'm a non-party, it was at my instance, I have not been added as a party.
can disposed of? Can disposed of? Can one of 2025 signs disposed of? Yes, Mr. Rai.
The petitioner of your lordship file. The petitioner of your lordship file an application, filed a suit for partition. And the opposite party herein being the defendant therein, filed an application under section 8 of the West Bengal Land Reforms Act.
Petitioner filed a partition suit.
Partition suit.
Yes.
In respect of his 1/3 share,
And the opposite party filed a preemption application
preemption application in respect of the purchase of the petitioners.
in respect of the purchase of the petition.
Petitioners.
Yes.
So if the preemption allowed, then there is no occasion for partition because I am claiming 1/3, they are the owner of 2/3. Am I clear to your lordship, my lord? So therefore,
You are 1/3.
I am 1/3, they are the 2/3. They filed an application,
So they are 2/3 means,
they will get its entirety.
if the preemption succeeds, they will be the owner of the entirety.
Entirety. And if the partition is affected, then also my share will be devolved upon.
What is the impugned order?
I filed an application for stay
Of,
of the party preemption.
that was rejected.
That was rejected by applying section.
Rightly rejected, Mr. Rai.
What, my lord, I am submitting with your lordship, my lord, if these two parallel processes, what will be the effect? If these two parallel processes allowed
Nothing
to
will happen. Nothing will happen.
that is why, my lord, precisely, my prayer before your lordship, my lord has the power of both the 24 of the Code of Civil Procedure and 227. My lord knows well the Honorable Apex Court judgment. If it can be heard, otherwise it will be a futile exercise. Both are running in.
Mr. Rai, it would be better if the other course is adopted. Partition suit should be stayed.
That,
Because partition suit is dependent upon the fate of the preemption. So partition suit has to be stayed.
precisely, my lord, if you logically consider
The ground on which preemption was filed, co-sharership,
co-shareship, now my lord, can you consider?
give me 2 dates. What is the date of the
Another thing, my lord, can you consider whether this point is available
preemption?
as of this day?
Show me the preemption application.
Yes, that is at page 12,
Yes.
2021.
Show me that paragraph which deed is impugned.
Yes, my lord, if you logically turn to page 14,
Page 14. Schedule C,
schedule sheet
22nd of December 2020.
2020.
So now show me the partition suit
Yes.
plain.
That your lordship find page 21.
Page 21.
Yes.
Show me the cause of action. part.
Yes, my lord, if your lordship can turn to paragraph 5, your lordship can consider.
Paragraph 5.
Posing that 2/3 share?
No. Paragraph 7 is the cause of action.
No, paragraph 5 is that the deed is the subject matter of dispute. My lord.
Yes, yes. But cause of action
This is paragraph 5.
is paragraph 7.
7.
Cause of action for partition suit.
Yes.
So, Mr. Rai, on admission, the preemption is to be allowed.
No, entire share.
That you take point.
The entire share.
Mr. Rai, that if you can succeed in the preemption, you succeed in the preemption.
That is why, my lord.
One thing, but with regard to this demarcation, your claim goes once you file a suit for
But
partition.
sir, that is
Because admittedly, it was a
share. So only for left.
partition property.
That is, I consciously, my lord, I am arguing this. The entire share is the subject of dispute. Now, my lord, as of this day, if your lordship allowed this preemption, my lord, whether this preemption,
That share preemption is not maintainable.
I don't know, my lord. It is my lord.
I will decide that.
Yes, then my lord, let me start.
Something remains after Chanarani.
Chanarani, my lord, can you consider Chanarani?
Yes, yes.
Chanarani is something else. Chanarani,
In this way, all matters, Mr. Rai, cannot be adjourned.
then my lord can decide whatever the special is, my lord can decide there. My lord is also a part of that bench.
I am also a part. Is it so?
Yes.
I am not aware.
Here is bench, my lord, your lordship,
Entire share.
57B.
57B is a different thing
No, no.
altogether, not in this.
It is
Entire share, I'm not a party.
Justice Tandon, Justice Vachari and Justice Kapoor.
I'm not a party in this. First. Second is, why stay? Because
Stay, but kindly consider in both the ways allowed to this.
what is the stage of both the suits?
It's previous stage, my lord. It is not that in such a manner it went to that extent. If you logically consider, no objection to the application. Section A.
Mr. Rai, the best thing would be let these two proceedings proceed in their own way, because nobody knows
What will be the that
of the larger bench when it will be decided.
that is why one
So let both proceed, no stay, because stay of the preemption, my prima facie view is should not be. Clubbing, you may be at difficulty because partition suit may be held up for
Yes.
this. This will be taken as a common.
that is why my lord precisely what my lord are praying, because there is nobody in a position to enjoy the property.
Both parties
So that is why my lord can consider his club together. If my lord
clubbed together, Mr. Rai, the difficulty will be you cannot proceed with your partition suit. You proceed with your partition suit.
ultimately
They are not
preemption
coming.
allowed.
They are not coming.
That
Mr.
is why I have to bloody from this
No.
code to that code. I have to all
Mr. Rai,
once for all everything will be
Mr. Rai,
decided.
kindly appreciate till uh, you have taken a point that the entire share. So I'm not saying it anything loudly. So you will take whatever steps to stall the
Preemption.
case.
That is
So, but you are the plaintiff in the partition suit. Let that proceed. If you get a degree, you get a degree.
then
Why are you trying to
no
mix up these two
because only once for all my lord it will be decided. If I'm entitled to enjoy the property, I'll enjoy. If my lord,
Why? Nobody is preventing you from enjoying.
But
You are enjoying. You are a
once-
purchaser.
if you logically, I have allowed the parties to continue up to the final degree process. Logically consider. At that point, the creation application allowed. It will be vested. Now, my lord, once it is vested, it becomes the entire. You become the owner of the entire property. Then, my lord, my status will be nothing but a. What will be my status over the
You will be without any status.
grateful to your lordship? Then, my lord, that is what because I have to spend money for the purpose of making construction and other things in the partition suit. After if I win, in the meantime, the preemption is not allowed. Once it both be allowed, yes.
Don't invest money.
That is why. That is why precisely, my lord.
Also, you cannot invest money now if the two proceedings are clubbed.
No, but preemption application, if your lordship, I may not get the cost of the construction or improvement. That is, I am conscious on that one. Upon that one, if both can be hard together. Yes, in fact, if it is allowed, I'll be out of court. I'll get the money which have been declared in the deed itself.
Mr. Rai, then I will have to record your submission. You are not pressing for stay.
No,
You are only
allowed.
paying for clubbing.
Clubbing. Yes, stay about it. It will not be any of the beneficial or any of the parties.
But that was the application which you have.
That is on the very beginning, my lord, was submitted to your lordship. Though it was couched in such a manner, but section 10, the Honorable Apex Court says, instead of stay the proceedings, it is better to club the proceedings.
By the order impugned, the application
So if your lordship is not inclined, my lord, it is not inclined.
Any application? No. Oh, it is starting, yes.
So my lord is recording that my lord is not inclined to pass in.
Otherwise, if it proceeds to some extent, it will be benefit to both of you.
Your lordship knows what will happen. Now we are in a streamline. What will happen? He has already passed.
That is why it's better let those two proceedings proceed.
As a lordship.
Yes, call the next matter.
Okay, I am for the petition, lordship. Lordship, this is arising out of partition suit, lordship. In this matter, lordship, learned court below, in complete violation of this honorable court's order, lordship, has proceeded to fix the matter for final hearing, lordship, without ascertaining or without adjudicating the issues with regard to existence of water body in the suit property in terms of this honorable court's order, lordship. If the order is in lordship, page 54. And relevant portion.
Where is the plaint?
Plaint is lordship. Plaint is lordship, annexure P1 lordship.
Annexure?
P1 lordship, A lordship, 18 lordship, 18.
Page 18.
Lordship.
This is a suit for declaration and partition.
Partition. Now, lordship,
yes,
this honorable court, lordship, was pleased to direct lordship to first ascertain the existence of water body in the suit property or not, because London Survey Commissioner, lordship, himself has pointed out.
Where is the order passed by
lordship, page 54, lordship.
Page 54.
Lordship.
In what proceedings?
Lordship, an order 18 bulletin application was filed before the learned court below, lordship, for inspection of the suit property. In view of there is a watery portion in the pond, lordship, before learned court below, learned court has rejected, lordship. Against that order, I have preferred this an application on Article 227, lordship. Pursuant to that, lordship, this honorable court was.
Give me a minute.
Lordship. Relevant portion, page 58 and 59.
So by what happened by the impugned order? Impugned order was for hearing on the commissioner's report. Commission was held.
Commission was held. After that, order 18 bulletin was applied, lordship. In view of the fact, commissioner himself has pointed out there is a pond.
Yes.
Measurement of pond. But lordship kindly sees the relevant portion of the order.
Raise all the points at the time of hearing of the commissioner's report.
Lordship, that hearing has been also postponed by this honorable court for ascertaining the suit property, whether existence of water body. If your lordship kindly sees, lordship.
Where it has been postponed?
58, lordship. Page 58, relevant portion. Last paragraph, page 58.
Yes.
In the view of this court, the issue of the partition commissioner's evidence and report being contrary and also inconsistent with the photographs relied on by the petitioner is clear from the records and should be decided before final arguments are made.
It's not the final argument.
Lordship,
it has been fixed for deciding on the commissioner's report.
Lordship, kindly sees the order just before the impugned order. Page, I am saying, lordship, page 74, lordship. Page 74.
Yes, 74.
The previous order of the impugned order. Last paragraph, lordship. Fixing 17/12/24 for hearing on the issue with regard to existence of any water body.
Yes.
And hearing
that was the direction.
Lordship, subsequently, lordship, the very next order, impugned order, lordship, what they did, learned advocate, lordship, because of sickness could not appear on that date, lordship. What they did, lordship, today's fixed, lordship, plaintiff filed a dependent on also.
No, these applications have been fixed for hearing. What is that, page 74? That has been fixed for hearing on 2nd of April.
For existence of water body, yes. For ascertaining water body.
Yes, commissioner has undertaken the commission work. He has submitted a report. On that hearing will be made. These petitions, where are these petitions? This is not for the final argument of the suit.
Lordship, that commission.
Where are these petitions? Where are these petitions?
Order 18.
Not order 18. 1st of December 2020, 12th of April 2022, 16th of July 2022.
I'm coming to the suit.
So these petitions will be heard.
Lordship, these petitions are. But before the commissioner report is also being has been fixed to be heard.
But yes.
But lordship, in
hearing of the commissioner's report is not the final hearing of the suit. What are you saying?
Lordship, but lordship, before ascertaining the suit properties water body, lordship.
That is why the commissioner has submitted a report. So unless a hearing on the commissioner's report is made, how can that issue be decided?
Lordship,
The
kindly,
commissioner's report is only a piece of evidence.
Lordship,
The trial court has to finally decide over the matter.
Lordship.
So commissioner has submitted the report. Hearing has been fixed on the acceptance of that report.
Lordship, hearing is not fixed on that acceptance, Lordship, pursuant to, Lordship, subject to correction.
Finally come to the last line of the impugned order, adjourned to 2nd of April for hearing of the commissioner's report at the petitions.
But before that, Lordship, that impugned 74, Lordship, the order before that impugned, Lordship, that commissioner report was not fixed for hearing. That was kept at bay, Lordship. For the sake of, Lordship, that hearing on the issue with regard to existence of any water body and hearing of 3 petitions. That part has been skipped, Lordship, in the very next portion, Lordship.
No, it has not been skipped.
Because that is
Same thing
separate,
for hearing and the petitions. Ashun. The learned advocate appearing for the petitioner submits Yes.
Ad interim order was refused, Lordship. I prefer an appeal, misappeal.
Yes.
That has been affirmed. If your Lordship will kindly come to the trial court's order at page 28. Page 28.
What is the suit for?
Declaration, suit for declaration and injunction.
What is the nature of the suit property?
House property. Now I have, along with the order 39 rule 1 and 2, I have submitted all the documents to establish my possession over the suit property. If your Lordship will kindly come to the page 33.
Give me a minute.
Lordship.
You are claiming title by way of adverse possession.
Lordship. That is my case.
What was your status when you initially entered into the suit property?
Lordship, that I have stated, Lordship.
Permissive occupier.
Yes.
So permissive occupier
My
can be
case,
converted to adverse possession.
the original owner
Permissive
left
possession.
for Bangladesh, Lordship. The
I'm
original, that
asking
is
you,
my
your
case,
initial entry was permissive.
Lordship.
Can it be converted to adverse possession?
No, that is a subject matter of suit. That
I'm
is
asking
different.
you. I'm
But
asking you, prima facie case is to be gone into.
Prima facie case has to
So
be
I'm
gone into-
asking you whether this converted permissive occupation can be converted to adverse possession.
But that is a subject matter to be decided.
Mr. Rai, prima facie case.
Prima facie case, not prima facie title,
Both
Lordship.
the courts below have refused.
Why? Kindly go through the order, how they have refused.
I'm expediting the suit.
But your Lordship will kindly see, ad interim was refused by the trial court. Now the order by which the appeal court has disposed of, he has clearly stated you don't have any prima facie. What is left with me before the trial court in my
Your
injunction
entry to the suit
application?
property was permissive.
Yes.
Now you are claiming adverse possession.
Lordship, my possession has to be protected.
Permissive. Now adverse possession.
Lordship will kindly consider the documents. All the documents kindly come to page
All right.
33.
Sir, both the courts below have refused. There is no scope to pass any interim order.
No, interim order, Lordship will kindly see how the trial court has dealt with the matter.
Mr. Rai, 17th of May 2024 was the refusal by the appellate court. Today we are on urgency is lost. Sir,
So we have applied
interim,
we could
nothing.
not get the certified copy of the trial court also.
Mr. Rai, ad interim,
Lordship, let me start.
urgency, lost. Or I can expedite the suit. You have two courses open.
Let me serve, Lordship. Let me serve.
By the
I'm appearing, I'm appearing for a week's time, I'm appearing to the petitioner, I'm praying for a week's time,
Sir, accept adjournment, say anything, accept adjournment.
The
The 7-3 has been allowed.
yes,
7-3 has been allowed. So now still you are praying for time. This shows the bona fide of your client.
the advocate of the petitioner, is extremely ill, has been advised to take bed rest, and could not come to court, A week's time, I'll come back with.
Week's time, do not know when it will come. The learned advocate appearing for the petitioner prays for
I am for the petitioner, my lord. My lord, against the order in a case for grant of letters of administration, I have come before your lordship.
what do you want? Expeditious hearing.
My lord, that one.
Expeditious hearing.
My lord, you see the conduct of the court.
What do you want? Expeditious hearing.
Of course. But the problem is the court remains vacant. The court of the district delegate remains vacant.
Court of the district delegate is vacant. Then it's difficult to fix a time. Ashun, this application under Article 227 of the Constitution.
My lord,
of
the
India.
district
Yes.
I appear for the plaintiff is the petitioner before your lordship, my lord. Suit for declaration, injunction and partition. The evidence adduced, my lord, cross-examination is complete. At this stage, my lord, when the argument is stage, my lord, he has filed an application under order 7 rule, order 18 rule 17, my lord, for my lord, recalling of the witness. My lord,
For producing certain documents
Yes.
which are inadvertently.
Right.
Mr. Bhattacharya, you are the plaintiff, you want your suit to be expedited.
that is there. That
So I'm directing on what is the next date?
next date is your lordship, 9th January.
Otherwise, your suit will get delayed.
That I follow, my lord, but the Supreme Court says, my lord, this is not permissible. That is, I have.
I know that under exceptional circumstances, those have to be made. Unless that is made, choice is yours. If you say so, then I have to admit it will get delayed.
May I pray this matter, your lordship kindly take up the matter next week, I shall take instruction. To fix the matter next week, I shall take instruction. And my lord,
Next week, it will not come.
that's,
Once it crosses, it will go.
your
If you
lord-
want, I can fix it at in the monthly list of April.
your lordship fix it.
Monthly list of April. After some argument, Mr. Bhattacharya, learned advocate, appearing for the petitioner.
That is why they have not lodged any caveat. That is why prudent advice.
So that is why if I direct you to serve, nobody knows when it will be taken up.
That I,
If it is the other, I can direct this examination on recall to be concluded on the next day. If not, consecutive days, I to dispose of the suit.
your lordship pass that order. Your lordship pass that order.
What is the next date?
Next date, here it is the 9th of January.
9th of January.
That
has
is
gone.
over. That is over. Next
What-
date, I have no instruction. Just 19th of March. Yes.
19th of
Yes,
March
fine.
for this.
Yeah.
So I think it's better.
Yes.
First up. By the order impugned. কিছু বলেছে কিছু? Out of Yes, call the list.
19. My lord, I am the petitioner of this, the suit for declaration of permanent injunction, accounts and redemption of the mortgage properties against the defendant bank who financed, under finance due to his unfinance, my entire project has been lost, and that's why I filed this case. Initially the learned trial court granted injunction, all these things, and defendant number 1 to 4 appeared in this suit on by
You are aggrieved by the order accepting the written statement.
Yes, but they have filed two application for vacating the petition. But please have a just look at page 64. Just 2-line petition.
Why do you want a ex parte order? Let it be a contested one.
No, my lord, there is the petitioner has acquired a valuable right as per Order 8, Rule 10. My lord, please have a look at the
Order 8, Rule 10. Court has to pass a degree.
Yes, according to provision. But I am just reading out, my please. Where any party from whom a written statement is required under Rule 1, that is within 120 days or 9, fails to present the same within the time permitted or fixed by the court. The court fix the time. As the case may be, the court shall pronounce judgment against him or make such order in relation to.
Yes, or make such order.
Yes, that is.
It gives the discretion. It's not that has to pronounce.
No. I am just coming.
Have you brought any decision in support that court has to pass a judgment? There are contrary judgments on this.
I have a judgment, but at this stage I have not, but I can produce it, my lord. To make such order in a suit as it thinks fit, and on the pronouncement of such judgment, the degree shall be drawn up. Provided further, no court shall make an order to extend the time provided under Rule 1 of this order for filing the
Order 8, Rule 1 and Order 8, Rule 10.
That's
Conjoint reading shows that the court has the power to extend time.
Not
that
court
it takes away Order 8, Rule 10, takes away the power of the court to extend. And it has to necessarily pronounce a judgment.
And
that.
Court passed expiry order on.
All right, you serve the petitioner by the order impugned. The
The plaintiff's application under Order 617 has been rejected.
rightly,
Right.
After commencement of trial, Mr. Rai, so rightly, proviso not.
Then, my lord, can you consider, if that be so, my lord, can you consider the defendant's amendment was allowed? If it was allowed, I filed an application after that.
Cause was shown, proviso
Nothing.
satisfied by the defendant.
My lord, can you consider what is the amendment sought for by the defendant and what cause has been shown? Can you turn to page 20?
So you are against both?
No. Let them allow. I am not standing on that. So far my amendment is concerned. It is one suit for declaration. Suit for declaration injunction, my lord, if you logically turn to the.
What stage you have applied?
After PW.
After PW?
PW, yes.
After cross-examination of PW?
Yes.
Show me the plaint.
Yes, my lord. Can you turn to page 10?
Yes.
Declaration and permanent injunction. In their written statement, we are claiming title over the property. The defendant, on the basis of the erroneous recording in the record of rights, tried to.
Where is the amendment?
Yes. Now, my lord, can you turn to the application is page 15. WSA copy আছে? That previously a suit was filed by our predecessor against the defendant, and ultimately it was degree was passed. They preferred an appeal dismissed. In spite of that, in the record of rights, their names are featuring as permissive occupier.
First part of amendment, all right, but the second part, that আপোষে দখল ছাড়িয়া দিয়াছে, this is trying to change.
That I am.
The earlier thing is with regard to the proceedings. Earlier
There is a
proceedings.
suit for eviction, my lord, suit for eviction, recorded position degree. They preferred an appeal.
What the trial court has said.
Now, my lord, their objection, my lord, can you consider their objection?
No, what is the finding of the learned trial?
Only delay. But my lord, that is only ground. Subsequently, my lord, the Honorable Appeals Court says there is some judgment, yes, to the extent it might be a ground for rejecting. But if it is a bona fide amendment, then also, my lord, you logically consider the latest judgment of Justice Bindal's judgment sitting. Then if it is meritorious, if it is required to avoid multiplication of proceedings, then those amendments should be considered in some other way. If the other side is can give compensation with cost. Today, my lord, if you logically defendant's application amendment was allowed, now the suit cannot be termed to be in preemptory vote. It should be brought back to the initial stages. And so the merit was considered according to that health. Consider the submission and peruse the plaint, written statement, amendment application, and its written objection, as well evidence of PW1.
Kindly come to paragraph 6 of your plaint. Page 12.
Yes.
What is your case made out in paragraph 6? Are you not trying to make out a new case by way of amendment?
Amendment, my lord, what is the case made out? I have never.
Kindly come to paragraph 6 first.
Yes. জনবদ্দি খাঁ বিবাদী পিতাকে নাংশি এতনগর অনুমতি দেন নাই। পিতাদের পূর্বধিকারী মোহাম্মদ খাঁ প্রায় 50 বছর পূর্বে পরলোক গমন করেছেন। সেটেলমেন্টের সহিত যোগাযোগের রেকর্ডে অনুমতি দং মোহাম্মদ খান লিপি করিয়া আকার দৃষ্ট হইতেছে। So this was the statement I made.
Yes. Now kindly come to page 16, second part of that schedule. What is dokhor?
Your lordship,
It will be dokhol.
yes, Dokhol.
Dokhol. Yes, so
The suit was filed, there is no,
দখল ব্যবহার করেন নাই
না,
ওয়ারিশ সূত্রে দিনেকের জন্য what is this?
my lord is page 16.
Page 12, paragraph 6. I'm trying to compare with your application for amendment schedule.
Paragraph 6.
Yes.
50 বছর পূর্বে পরলোক গমন করিয়াছেন। বিবাদীগণ সেটেলমেন্ট কর্মচারীদের সেই যোগাযোগে রেকর্ডের অনুমতি দং মোহাম্মদ খান লিপি করিয়া রাখার দৃষ্ট হইতেছে।
Yes.
নালিশির আগে বিবাদীগণ ওয়ারিশ সূত্রে দিনের কয়েকের জন্য দখল ব্যবহার করেন নাই।
নালিশের আগে ওদের কোনো অধিকার নাই। So
ওদের কোনো অধিকার নাই।
Yes.
সম্পূর্ণ নিঃসত্ত্ববান ব্যক্তি হইতেছে।
Yes.
So this is basically they have no title over the property and they have no possession. And now one can consider
Now kindly come to this
page 16.
16. Yes.
That initially my lord সেখানে ইতিপূর্বে জ্ঞান অধিকার উত্তর মোহাম্মদ খানের পুত্রগণের বিরুদ্ধে my lord kindly consider পুত্রগণের বিরুদ্ধে মাননীয় দ্বিতীয় সংসদীয় আদালতে সম্বন্ধে 17 বছর দখলপত্র স্থায়ী নিষেধাজ্ঞার দাবিতে এত তারিখে একটি উক্ত মোকদ্দমা এত তারিখে অনুকূলে রায় ডিগ্রি প্রদান করিয়েছে। So there was the title possession in my predecessor was accepted. They have no right to interest over the property in question.
Next.
After উক্ত মোকদ্দমা এত তারিখে জ্ঞান অধিকার অনুকূলে রায়
সাত আপোষে জ্ঞানাধিকার
পশ্চাৎ বিবাদীগণ রায়ের বিরুদ্ধে
দখল ছাড়িয়া দেন।
yes. Now, my lord, they have
So
proved their
this is
position.
contrary because there you have said that they were not possessing for 50 years. So now you are saying you are possessing after this judgment and decree, they have amicably given us possession. So this is contradictory.
অনুমতি দাও my lord, can you
So
consider
this was transfer a title appeal. So when this title appeal was dismissed, so this
No, it's
possession
subject to
was
consider-
given amicably. So it was within 50 years and you said they did not. So this will be contradictory to your
the subject to
original
consider, can you
pleadings.
turn to paragraph 12, page 12, paragraph 6.
Yes.
বাদীর পূর্বাধিকারী জ্ঞানাবধি খা বাদী বিবাদী পিতাকে নালিশি 22 দাগে দখলের জন্য অনুমতি দেন নাই। বিবাদীগণের পূর্বাধিকারী মোহাম্মদ খান প্রায় 50 বছর পূর্বে পরলোক গমন করিয়াছে।
Yes.
বিবাদীদের সেটেলমেন্ট কর্মচারীর সহিত যোগাযোগের রেকর্ডে অনুমতি দং মোহাম্মদ খান লিপি করিয়া রাখার দৃষ্ট হইতেছে। Pause here for a moment and my lord, can you consider
Next. বিবাদ নালিশি দাগে বিবাদীগণ ওয়ারিশ সূত্রে দিন কয়েকের জন্য দখল
ব্যবহার করেন নাই। নালিশির আগে উহাদের কোনো অধিকার নাই।
Yes.
ওরা সম্পূর্ণ
So
নিঃস্ব-
now they did not possess. Here you are saying that for how many years?
Yes,
You are
that is
saying-
why my lord, can you consider the suit was filed not,
Mohammad Khan.
yes.
So now you have said
Mohammad Khan
yeah.
পুত্র, Mohammad Khan died prior to that.
Yes.
That is why suit was filed against the son of Mohammad Khan, who are the defendant.
Yes. Here you are trying to make out a case that they amicably handed over possession. to-
Position. Even if Balar Kali consider suit for declaration, injunction, and for earlier suit was decreed in favor of my predecessor. Holding yes, I am right at interest, and there is a degree for recovery of position. According to me, my lord, they have delivered position, and subsequently, my lord,
A minute. Rightly, calmly come to the impugned order. So they have disclosed about these proceedings in the written statement and you have denied that in your evidence.
defendant also came to evidence plenty in form of denial.
Yes.
My lord, can you consider what is the denial made?
Of these proceedings, that is the evidence trial court has recorded. Give me your PW1.
এটাই তো নেই।
That is the recording. So you have, so the fact of the earlier proceedings is on record. For that, you need not amend your pleadings. And you have denied that. And this fact was disclosed in 2020 and this application is 2024. So delay not explained. Rightly.
My lord, delay if you logically consider the
From 2020, these facts were disclosed. So you could have approached then and there. 4 years delay is there.
So that is what, my lord, this is a suit for declaration, my lord, of a title, my lord, if kindly consider.
There was some object for bringing in the proviso, Mr. Rai.
Yes, that is, if it is at all necessary.
Your suit, it
Well,
may be delayed.
if it is necessary.
My suit, it will be delayed.
Whether it is at all necessary, this
Your
amendment.
chief,
Chief আছে? Chief? আছে? Chief is not. But whether privacy, this is a suit for declaration injunction. Till today, my lord, it will be a suit for declaration title and permanent injunction.
you have, Mr. Rai, you have denied these
So, but
proceedings. Now you are trying to incorporate
deny the
those.
proceedings which was
Those are there. Mr. Rai, these things are on record. They will bring these documents. So you can make your arguments on that.
if you logically
What is
consider,
the effect of that decree?
Yes.
That your title or your predecessor's title has been declared there. So you take those points there.
if you logically consider that what they want to incorporate and why it is pay and accept.
That you are not challenging.
No, the same deed. If that was carried by amendment, my lord, can turn to the last portion,
Of page,
page 20.
their application for amendment.
Yes.
Yes.
বিবাদীগণ দখিল বন্দ্যোপাধ্যায় 21 দফায় মতো দলিল সম্পন্ন উল্লেখ করে বাদীগণ এক্সিবিট জানা যায় দলিলখানি শশীভূষণ দাস মাইলট স্কিপ ওভার ওই সম্পাদনা তারিখ সংশোধন করার জন্য বর্ণপত্র 25 দফায় এবং 1983 সালের 96 মোকদ্দমা গত ইংরেজি 30/8/89 তারিখে রায় হইয়াছিল মর্মে উল্লেখ করিয়াছে। এই বিবাদীগণ ওই মোকদ্দমার রায় ও ডিগ্রি জবরদখল বাহির পূর্বক জানিতে পারে যে 96 দেওয়ানি মোকদ্দমা 30/3 তারিখে রায় ডিগ্রি হইয়াছিল, তবে সে তরিখানি সংশোধন করিবার জন্য 26 তারপর টাইটেল আপিলে এত নম্বর মোকদ্দমা প্রকৃতপক্ষে এত তারিখে আদেশ মূলক নিষ্পত্তি হইল ভ্রমত্বক ভাবে এত তারিখে লিপিবদ্ধ হয়েছে। ভ্রমত্বক লিপিগুলি সংশোধন করার প্রয়োজন। So this is the factual aspect which is the subject matter of adjudication in the earlier suit also.
So they have brought in. So after you have laid evidence with regard to that, they have brought in this.
So therefore, my lord, if you
So
logically,
this has come. This has come.
that is why, my lord, can you consider whether it is a sought for amendment is arbitrary derogation or mutually destructive in nature or not. I have today, my lord, can you consider if today it appears that I am not in position, they are in position in view of the earlier judgment, then my lord, I have right to amend, my lord, that is that amendment,
What
section
you have
34, section 34, my lord, then question court whether the suit is barred on section 30. Whether I can apply for the, if it is found that I am not in position, then I have the recourse to file an amendment and
That is not the amendment.
no, that is why. So still I am on the basis that yes, I am in position. I have to prove my position.
That is your plain case. You are in possession.
Yes.
Now,
my lord,
now you are trying to make out a new case that amicably he has handed over possession to you.
they have to say the what status they are in position, if they at all. So if I fail to prove that I am in position, it is merely by handing over position, mere statement will not do. I have to prove my case. My case will not depend upon the defense pleadings or defense witness. So even if by not today, if I get,
Delay 4 years. Delay, Mr.
it is therefore the only comes
Yes,
boils
yes.
down to delay.
Proviso, unless proviso, you can cross
Yes,
the order.
first,
Merits cannot be looked at.
consider whether this amendment is absolutely baseless or it is some ill motive.
Where is your chief?
The chief to আসেনি, chief to আসেনি.
Without going to the chief, Mr. Rai, how could you prepare yourself? This is the
Eh,
finding in the impugned order.
My lord,
These are the evidences.
law laid down by your lordship's courts, this courts, that while adjudicating the amendment application, merit need not to be gone into.
No. Merits need not be gone into. But the question is whether you are trying to make out a new case.
New
which is
case, what
contrary to the-
what the objection?
That is maybe the objection. The trial court has recorded this.
Yes, that's
That you have denied all these facts. Now you are trying to
what are the
incorporate
my
those
lord,
facts.
consider what are the facts which have denied? What are the question put in the chief, my lord? What are the
That
question?
is why I want to look
Now,
into the
If
chief.
you logically consider, if the
Bring
chief
the chief, Mr. Rai.
plate is there,
Bring the chief.
I'll bring. Well, can you consider the chief? What will be there? The plate case? In the plate case, there is no iota of evidence regarding this.
No, this denial is also there. That is the recording.
How could they?
Paragraph has been mentioned, paragraph 24 and 25, because this was after they have disclosed in the
Therefore,
written statement. You
Yes.
have filed your chief denying all those.
evident cheap, my lord.
Mr. Rai, for the purpose of controverting the statements made in the written statement, you need not amend your plaint. So in the chief, you have denied all those facts. Paragraphs have been mentioned in the impugned order 24 and 25, Mr. Rai. Show me your chief.
ঠিক আছে? That is not. But what is the trial court proceeded as if it is a delay? If you logically consider
Yes, yes. Delay is also,
delay, only on the ground of
I am also with the trial court. Delay is there. 2020, this fact was disclosed of these proceedings and you filed in 2024.
I am entitled to get protection until 2022 March. I am entitled to get protection up to 22nd March. That cannot be taken away. Corona.
By the order impugned.
May I please your lordship?
Yes.
My lord, this revisional application has been filed against an order passed whereby my Order 7 Rule 11 application has been rejected. Order 7 Rule 11 application has been filed by the Finance Asset Reconstruction Company in the title suit stating that the entire dispute has to be decided by Debts Recovery Tribunal. And on that ground, Order 7 Rule 11 application has been found and stating that Section 34 of the SARFAESI Act clearly bars.
How it has been dealt with?
Yes, my lord. May I just place the impugned
Where
order?
is the prayers in the plaint?
Prayers in the plaint. My lord, prayers in the plaint is at page 24. And I'll just show that what triggered the tenant in order to file this suit.
Oh, this is a suit by the tenant.
Yes, my lord, may I just give a very short background and then it would be easier for
Tenancy prior to mortgage, after the mortgage.
after the And moreover, my lord, what the learned court below has failed to consider is that the learned court below went on to decide that he is challenging the eviction, the notice that was given by the landlord seeking eviction. However, failed to consider that it is the Section 14 order passed under under the SARFAESI Act which triggered the tenant in order to file this suit.
Show me that this tenancy was prior, after the mortgage.
Yes, my lord. My lord, kindly see the averment at para 10, page 21. And para 5, page 20. This
Para
para
10.
Para 10. So it's in 2000. And my lord, kindly
tallies it with page 3, page 20, para 5, just the paragraph page prior to that. In November 2002, this plaintiff was inducted as the tenant. So admitted fact that the plaintiff being the tenant was inducted post mortgage.
Ashun, by the order impugned, None appears for the petitioner at the time of call. No accommodation has been sought for either. Same order. Next. Dismiss for default.
May I please, my lord? I am for the petitioner, my lord.
Yes.
In this matter, my lord, there is an execution case, my lord. There is a settlement arrived at between the parties, my lord, that there is a terms of settlement. This we shall pay the digital amount in, my lord, installment, my lord. Now, my lord, installment pair of installment was allowed, my lord. Subsequently, my lord,
Who filed the review application?
my lord, review application has not been filed. My lord,
For hearing of the review application.
May I please, may I give this order sheet, my lord? This is the order sheet that wrongly annexed, my lord. This is the right order sheet, my lord. This order sheet, my lord. In this matter, my lord, their review application has not been filed, but leave has been granted to file leave application. Pursuant to that, this is a revisable order, my lord. My lord, kindly have a look this order, my lord. Order
You are the judgment debtor.
I am the judgment debtor, my lord. There is a conclusion arrived at on that.
Give me a minute.
Yes, my lord.
Yes. Have you made the payment?
My lord, I have ready to make the payment, and my lord, kindly have a look the order dated 16/12/2000.
Readiness will not do.
No,
You are directed to pay within 16th of December.
yes, my lord, I am ready with the draft, my lord, but the decree holder refused to accept. Then, my lord, the granted court.
Why the degree holder refused to accept?
Sir, kindly have a look the impugned order, my lord. It is his whims, my lord.
No.
My lord, last order, my lord, in impugned order 16/12/2024.
You said 6th of December is the impugned order.
Not, it is a first order, which I am not agreed, my lord.
Yes.
I am ready with that order, my lord. My lord, impugned order 16/12/2024, last order, my lord. Last order, my lord. My learned court below granted leave to file review application, whether the 6/12/2004 is the revisable order and contested on, and
He wants to file a review.
No, I do not want to file review application.
Not you. The decree holder wants to file a review.
But court should not have granted liberty to file review application. This may be adjourned. But my lord, thing is this is a revisable order, my lord. My point is this: if the liberty is granted, my lord,
is there any bar to file a review? If there is a error apparent, maybe it's a revisable order, and he can approach the court with a review. Is there any bar to file a review application?
May I submit? My lord, kindly have a look the second line, my lord.
Yes.
On the other hand, the learned counsel for the JDR is ready with the demand draft.
You cannot be aggrieved by that. No order has been passed against you. Only a liberty has been given to file review.
Well, liberty, if the liberty is there, my lord, they have.
Nothing is there. Yes.
An application, my lord.
then-
Let kindly direct the judgment letter should be submitted that much
Will be
only.
served. Yes, call the next matter.
25 and 26, Mr. Bhattacharya is appealing.
Since I'm not inclined to take up this matter on personal ground,
But I'm for the petition in this matter.
yes,
27. But here the opposite party initially filed a suit for eviction, which was decreed in favor of them. I preferred an appeal within time, and the appeal is pending. Now they have preferred an execution case. That execution is proceeding because the appeal has not been taken up. I preferred a put up application before the appellate court stating the urgency that has also not been taken into consideration. Appeal.
file an application for stay.
Stay is there, stay is pending. The learned judge is not taking up the
Stay is pending.
Stay is pending. I'm just next date for execution is fixed on
What is
8
the
April.
property?
That is a shop room
Shop room where?
at Howrah.
Howrah.
Lordship.
So what is the extent of the shop room? Pay occupation charges. I will pass an order of stay of execution for a limited period,
My lord,
subject to the decision of the appeal court to fix the occupation charges. Where is the property? What was the rent?
my lord, the rent was initially 70 rupees per month.
Was rupees
70 per month.
70.
Lordship.
What according to you is the market rate of rent in that locality
But
for commercial purpose?
yes, take instruction on this issue from my client. May I come back on tomorrow with the market price rent or lordship?
What is the extent? What is the extent? Show me the decree or the plaint.
The
Wherefrom I can get an idea. Yes.
plaint is at
Judgment
page-
is there. Decree has been annexed.
decree has been annexed. Schedule of the plaint is at page 21. Pakka shop
What
room
is the measurement?
that has not been mentioned.
Shop room, veranda, back, adjoining kitchen.
Kitchen. Holding number 212,
Yes.
Poshamipara Road, Bali.
15,000. What was the date of the decree?
Date of the decree, my lord. Decree is at page 40. In the decree also, my lord, the total measurement of the shop-
19th of January 2024.
2024. 19th January 2024.
So pay lump sum amount at the rate of 15,000 deposit.
Lordship,
Occupation charges to be decided.
15,000 per month.
Yes, yes. From the date of the decree till this date,
Well, may I take,
calculated up to March.
may I take instruction because it will be a
You
huge
can
amount.
take instructions. The execution will proceed. No stay.
On 8 February, the execution, my lord, kindly keep it on tomorrow, my lord, I will come back with the instruction.
Instructions will not help. You may
Lordship,
come up with an
because
instructions
it
of
is a
rupees
huge
100,
amount. It is more
the
than-
market rate.
it will be more than 1 lakh, 1 and 5 lakhs. So, my lord, I have to take instruction. It will be more than 1 and 5 lakhs, my lord.
Or you move your application for stay. I will give you the liberty to move the application for stay
Well,
before the court. What is the date fixed for the
Difficulty is
stay
the
application
application
to be
was
heard?
fixed on 28th April when the learned judge was not available. So next date fixed on 19th May 2025. And next date of execution is fixed on 8th April 2025. But I'm one pilot before this 8th April.
27th of February was the date for execution. What happened on 27th of February?
27th of April, my lord, the
27th of February.
27th of February, that writ was not executed.
You resisted.
They are not resisted.
Otherwise, you has to
On
be
that day-
executed.
On that day, that was not executed. So on the next day,
Why it was not executed? What is the reason for not execution of the writ? You resisted.
Lordships. Because my application for stay has not yet been heard. That is the difficulty. My
The client
application-
is here.
May I take
So take instructions.
ফেব্রুয়ারি 19 ফেব্রুয়ারি আপনার ডিগ্রি হয়েছে 19 ফেব্রুয়ারি থেকে আজ অবধি 15,000 টাকা পার মান্থ ক্যালকুলেট করে জমা রাখতে পারবেন কোর্টে
কত মাস
19th April.
All right, come tomorrow.
Lordship, may I-
An accommodation has been paid for by the learned advocate for the petitioner. List this matter tomorrow under the heading motion.
I'm grateful.
Yes. Next.
I am for the petitioner praying for not pressing this application and seeking liberty to file afresh.
Why?
There is certain discrepancy in the application. There is certain
What are the defects? Tell me. What are the defects?
instruction, my lord.
Yes, if you want to not press, that leave can be granted. But liberty to file afresh, what is the defect you have to show? What is the defect?
My instruction, my lord.
What is the defect?
I don't have instruction, my lord. Yes.
Tell me what is the defect? This withdrawal with liberty is not automatic. An accommodation has been paid for by the learned advocate for the petitioner. In view thereof, the hearing of the matter stands adjourned. Yes, next.
9.
Yes, Mr. Banerjee.
In this case, my lord, predecessor interest of the principal opposite parties.
Who are you?
I am defendant number 2, judgment date.
Yes.
My lord, predecessor of interest of the principal opposite parties filed a eviction suit against the petitioner and pro forma opposite parties. Learned trial court decreed the said suit. The judgment debtors preferred an appeal against the said judgment of the trial, and degree holder put the degree in execution. And in the execution proceedings, the degree holder filed an application, Rule 208 of Civil Rules and Order. Executing court fixed 9th April 2025 for hearing the date of said application. Judgment letter.
So you want stay of the execution.
Stay of the execution, my lord. Appeal court.
Same principle, Mr. Banerjee.
Appeal court.
4th of March has been filled. What is the 151 application?
151 application, my
Is
lord.
for stay.
No.
Yes, yes.
2 application has been filed.
No, no.
One
Order
order
41, Rule 5, date with 151. What is the 151?
151, name of the judgment debtor has been wrongly substituted.
So tomorrow is the date fixed. I am directing tomorrow the
Okay.
4th of March.
Today. My lord,
Move your application today.
kept the said application on record. Stay application by the impugn order appellate court directed that kept the stay application on record. Requisite kept on
What is the suit property?
premises, my lord. I am
Residential, commercial,
I am a tenant of in respect of a shop room.
shop room. Where? How much, Mr. Banerjee, you are willing to pay?
Rent 19
Rate may be 19.
and premises
Inducted in 1960. Or prior to that? Yes, prior to 1960. So, after 19, how many zeros on the right hand side? 19 will be kept intact.
90.
Oh, 90. So, 90 will be kept intact. How many zeros on the right hand side after 90?
One small shop room, my lord.
Vacate that, Mr. Banerjee. Small shop
This
room.
is the
You want
only
a
source of one.
you want a larger accommodation for carrying out your business.
But this is the only source of stay application pending in the appellate court.
Yes,
Appellate
yes.
court passed the order kept on
Yes, yes, I will pass an order of stay subject to payment of occupation charges. You tell me what will be the reasonable occupation charges. Because
that may be done. Court fix the reasonable charge. Court can fix the reasonable.
for some lump sum amount to deposit, what is the date of the decree?
It will be 7th August 2024.
2024. Deposit 75,000.
It is impossible to pay by my client.
Otherwise, please vacate.
On shop room. My lord,
if you want to move to a different shop room of the, in the same locality of the same extent, do you know what is the market rate? Which is the area? Where is it situated? Howrah, commercial hub of the state of West Bengal, Howrah. What happened? This application has been taken up today, 4th of March.
Kept on record. 151
No,
application,
stay application.
stay application kept on record. My lord, see the impugn order.
Why kept on record? You did not move that.
No, my lord. See the impugn order. Last line.
All right, so pay 75,000, I am staying that. Otherwise, no stay. Let it be executed. Maybe. Attaram is there. Attaram is there.
I know, my lord.
So you have to pay occupation charges.
It is beyond capacity of my.
Otherwise, no stay, I can direct you to serve. No stay.
Otherwise, prior 9th April, exhibit were fixed 9th April for hearing of the
9th April.
9th April.
All right, so let the other side come. So I will, in their presence, I will fix it. Will be more. Ashun. The Mr. Banerjee, learned advocate, appearing for
For the petition, so my voice has become very bad. For item
Mr.
number
Mukherjee,
30.
You want an accommodation?
No, I would only like to have a copy of what
Copy has not been
No,
served,
not
Mr.
been-
Mukherjee. Serve a copy.
There is no caveat. That's why my junior
It's
has.
now appearing.
Yes, not I shall definitely. Let us copy the.
Let them serve a copy. We'll otherwise do.
When this matter is taken up, Mr. Mukherjee, when
But
this matter-
my learned senior friend is appearing for. Sorry, 2B and 2C.
he is appearing. When this matter is called, uh,
You want?
But I am for the petition.
Yes.
কোনটা আছে 776
Yes, Mr. Banerjee.
Yes. But there were two revisional applications filed. One has come up today. Other is tomorrow.
7-2.
7-2.
Parvati Charan Rockety, your creation.
No. Parvati, this is a different circumstance altogether.
Your creation, Mr. Banerjee.
Here 7-2 is pending. 7-1 has been disposed of.
7-2 admitted areas not paid.
Yes. Paid.
So why it has been
7-1A complied, admitted areas paid. Matlab, thereafter, he was continuing his deposits. He faulted for a period of 1 month, and that too, within the 18th day, he made an application before the trial court showing that I was ill. Matlab, I was ill. The court observed, no, my lord. But I have a
Parvati Charan Rockety takes care of
Parvati
everything.
Charan Rockety is different. Parvati Charan Rockety is a different consequence. It is after disposal of 7.
Some period of short.
No.
Rupees or 20 rupees.
Yes.
Short for some
Matlab,
months.
that is a consequence after.
Your creation, Mr. Banerjee.
Yes. Matlab, that will not stare at me. Because that is a circumstance where 7-2 has already been disposed of. Here in my case, 7-2 is pending. During the pendency of the 7-2, this happened. But the trial court has observed that I cannot.
So your default is 7-1C.
7-1C.
7-1C, can the court extend?
My lord, those are the judgments, my lord. If your lordship may kindly consider that if there is a non-compliance of 7-1, but under any circumstances,
7-3,
automatically it automatically can happen. But in the given circumstances of this case, this is different.
Court's power to extend, show me.
My lord,
No application is necessary, Mr. Banerjee.
my lord,
So
kindly,
section 5
kindly, my lord,
cannot be applied.
kindly comes to the provision that is there.
332 West Bengal Premises Tenancy Act. What did the trial court say?
But the trial court said, after considering a judgment of Justice Ashish Kumar Chakraborty and a judgment of Justice Ajay Kumar Mukherjee, that I have no power of
Ashish
extension.
Kumar Chakraborty, wherein I appeared for one of the parties.
Yes. And my lord, I will show that submission. I will show that submission.
I lost, Mr. Banerjee.
My lord, no. Lordship had won. In that matter, Lordship had won. Appeared for the plaintiff.
Yes.
Lordship will kindly.
7-1C, yes.
Lordship will kindly come. There is a proviso after section 7-2.
So it will apply to 7-1C.
Lordship.
7-1C.
For a moment.
Devashish Pal.
No.
Direct answer to that.
My lord, in Devashish Pal, the 7-2 had been disposed of. In the Devashish Pal judgment, 7-2 had been disposed of. In my case, 7-2 has not
What
been
is the
disposed
effect
of.
of the proviso, whether it will apply to only
But
7-2
I have,
or entirety?
Lordship will
consider-
kindly see 7-3 once. Lordship will kindly come to 7-3 also.
Extension.
Extension.
Extension is in 7-2.
No, my lord, kindly see once. If the tenant fails to deposit or pay any amount,
Mr. Banerjee.
my lord, for a moment, but the legislature's intention was otherwise. If the tenant,
Parvati Charan Rockety is your creation.
my lord,
Mr.
Parvati Charan Rockety, Supreme Court has said no. Supreme Court has said no. Supreme Court has turned that order and said that the defense that was taken off, that may be given back and he may be permitted to proceed with this suit, placing his defense. I will show that if your lordship may so desire. Now, Lord kindly finds one thing,
Yes.
7-3, if the tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2 within the time specified therein,
or within such extended time as may be granted, the civil judge shall order the defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. But why did the legislature here include?
There is no caveat.
No. But the legislature also included 7.1, not only 7.2, but the interpretations that we are getting, but the judgments that have been cited, that have been considered by your lordships, those are in cases where the 7.2 has been disposed of. But my footing had to be absolutely different if my 7.2 would have been disposed of. I would have got 1 month time to make the deposit, and thereafter I would have been given an extension if I would have applied. My lord, here there was an 18 days delay, and that 18 days delay, court is holding, I cannot extend the time for 7.1. This is incorrect.
Mr. Banerjee, is there any dispute with regard to the rate of rent?
No.
Is there any dispute with regard to the period of
Period
default?
of default, yes.
So period of default, there was a dispute.
Yes.
So you deposited that amount.
But the area, admitted
Areas,
area, yes.
Admitted areas.
Yes.
Along with an application under section 70.
Yes.
But this is does not fall within that admitted areas. This is non-compliance of 7.1c subsequent to that.
Malad kindly appreciates. Malad 7.1c culminating into 7.2
There is
order.
no dispute with regard to the rate of rent.
Malad, I will show to your lordship, my lord, what the court has held. My lord, prima facie, I am to satisfy your lordship that in 7.1 application also, if there is non-compliance, there is a scope under 7.3 for extension of time.
7.3 for extension of time.
Lordship, the 7.3 says, if this tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2 within the time specified therein, or within such extended time as may be granted.
So according to you, in 7.3, the court has the power to extend the
No,
time?
my lord. 7.3 is non-compliance of this. Court is the provision is defense shall be struck off if I do not comply to this. Now here I am in a position where the 7.2 is pending, 7.1a disposed of, admitted areas paid. I admitted areas of the areas, whatever the areas were, I on my own deposited the amount. It was my contention. I had certain grievances in the 7.2 application. That will have to be taken up by the learned trial court. Now, my lord, I commit a default in respect of the payment of current rent. Court says I have no power. But this is...
Show me the order impugned.
Yes. It is 776. Lordship. 775 এর অর্ডারটা করল ওটা দাগ দেওয়া আছে আমার ইয়ার judgment.
Your defense has been struck out.
Yes, everything.
Ashun. Mr. Banerjee, learned advocate appearing for the petitioner.
on 9th of June. May we have the vacation.
April, I have directed the matter to be taken up.
Lordship kindly makes it 15th April. I mean, 15th June.
You
that
want
would
to
be
avoid
start.
the choitso
No,
pass.
no. I have no problems. It would be best if I can move it before your lordship, my lord.
Let it appear thereafter. Yes, call the next matter.
It creates a confusion regarding the extension. This is the whole difficulty.
There is no confusion. You are creating the confusion. When you are for the landlord, you will make one argument. And after obtaining an order, you will say no.
This has been the trend
For
for
the
so many,
tenant, it does not apply.
it has been the trend for centuries, my lord. Ungrateful.
Yes.
If time is not permitting, Lord,
What time is not permitting? You have
the next matter, no,
business anywhere else.
So, my lord, next matter, my lord, I have mentioned the citing the ground of urgency, my lord. So, my lord, make it not today. This,
So
my lord,
this
take-
client is not urgent for you.
No, my lord, next matter, my
All
lord.
right, I am recording that.
No, my lord,
Mr. Mukherjee Lanet,
my lord, not for that, my lord. Next matter, my lord, for
you are saying that
my lord, I have disturbed your lordship even at the time of rising for that matter.
you are saying that one client
Today,
is
my lord,
important.
today your
rather
lordship
than-
will not take up, my lord, the supplementary list, my lord, after the recess. That's why, my lord, I am insisting, my lord, next
You are
matter.
recording that.
No, my lord,
So
I
you
will
want
not
to prefer the other
not
matter.
record that, my lord.
before-
I will move this matter tomorrow. I can move this matter tomorrow also, my lord, for next matter, my lord, since I have mentioned.
An accommodation has been paid for by Mr. Mukherjee Lanet.
To do and what Miller in what way Miller thinks will go ahead. That is what the urgency is. Miller, if your lordship sees now that
Why are
application.
you involving the lawyers?
No, Miller. Miller, my learned senior friend says.
Have you made any complaint against the lawyers?
My lord, I do not know. The advocate on record in the trial court can say, let me submit, my lord. Yesterday, that
Why are you involving? The matters will be moved. That will be.
yesterday, my lord, that application has been rejected.
Which application?
That application involving the learned advocates, name of the learned advocate for
Implementation.
implementation. That has
But
been
the
rejected.
complaint is still there.
No. There is no mentioning of name. That has been passed yesterday. So they need not to be worried.
It takes
Yeah,
care of your.
They need not to be worried for that.
You first see, I have not seen that order.
Yesterday, they contested. They contested the proceedings. And the engineer commissioner made the complaint.
না সেটা মেরিটের ওপরে হবে, সেটা তো তুই এত অ্যাজিটেটেড হয়ে যাচ্ছিস কেন?
Let him serve the proper copy, my lord.
আমি তোমার দিয়ে দেবো, আমি দেবো। তুই তো পরিষ্কার লিখে দিয়েছ। My lord, allow me to take instruction on this. If this is there, my lord, because yesterday the judge didn't sit, probably he wrote the judgment there. My lord, yeah, it's in my favor, so why would I even think of other way? Then keeps it tomorrow, but order 26 rule 9 needs to go.
Order 26 rule 9.
Yes.
Day after tomorrow, my lord, then.
That, Mr. Chatterjee, then it is to be at the, because since you have
My lord, the
mentioned
complaint is
the
still there.
lawyers, that has been,
The complaint is still there.
that is another thing.
It's a
Complaint,
police complaint.
No.
that is Mr. Chatterjee.
Lord, records that my learned senior friend will not proceed with it. Kindly keep it
Certainly
wherever
not.
you are.
Certainly
I could
not.
record
Block
that
the record.
Certainly not.
My lord,
because this was upgraded only for that.
Very good.
Otherwise,
My lord
keep it
records it. This order, and that my learned senior friend has given word that they will not proceed with it.
and I will also have to record your submission that he will also not obstruct the commission work.
Yes,
No.
yes.
I'm challenging the commission work.
The learned advocate.
Advocate
Client,
will not.
Yes.
I will
No,
also
advocate. No advocate
so
will
take instructions from the advocate that
Yes.
Yes,
he will not,
I am giving instruction, my lord. For a lawyer, my lord, I don't need instruction.
this
need to be passed.
yes, next, call the next matter.
Yes. Yes.
I have, for my compliance, Miller.
Other side is here.
Miller, I have served, Miller. I have served. Lordship's ordered, Miller. This is, Miller, the affidavit.
Well, 34, my lord, I'm appearing for the opposite parties.
This is
My lord,
my-
even a while back, my lord, I spoke to my client, my lord, with a copy of the revisional application and no supplementary affidavit, my lord, has reached.
Well, I have given you a copy, my lord, and this is the affidavit
just
of
give him a
service.
copy, I'll
Yes,
keep
yes, and I have
Keeps it tomorrow.
I have complied with my lord's direction, my lord. I have, my lord, kept
He
the
says copy has not been served.
I have served. I have
Affidavit of
affidavit of service.
service.
I have given you a copy here and now. Where is the difficulty? Not to release, I have kept apart this sound, my lord.
Mr. Ghosh Lanet, senior advocate, appearing for the petitioner, submits that the order and direction on record করে দেবেন। This is the supplementary affidavit.
Nothing remains. but I have
Affidavit service
secured
and
the entire-
supplementary affidavit. একটু দেখে নেবেন, taken on record. Yes, call the next matter.
35.
Two PM is the monthly list. Tomorrow it will retain its position.
The problem is that the date is fixed before the lower court below is 6th March. The defense has been
Yes,
strike down,
tomorrow
we are suffering.
tomorrow
Kindly
is
fix it
tomorrow
on
is
the top. Kindly in the top. Otherwise the matter will not be taken. Kindly.
Yes.
Point monthly list, item number 32.
Yes.
But I need to maintain tenant in eviction. But I filed 7-1 application and go directly to deposit current rent on. Then, Lord, this is the order passed in the year 21.
21.
Yeah. Now, Lord, 23, almost after 3 years, he filed opposition 7-1 different and the recalling application of the said offer. And the same that application was allowed. My submission is the totally a belated application. He has not filed any application to explain the meaning. Your lordship kindly see page after page 27.
What is the date of the impugned order?
After page 27.
No, what is the date? 10th of September.
Yes.
Where is the plaint? Where is the plaint?
The plaint, yes. Plaint is read your lordship kindly see. Page 8. Here, lordship note order 21 on against expiry order, but recalling of the expiry order, you have to file the reaction. Explain. Seven years yet not resolved.
The suit is not under section 6 of the West Bengal Premises Tenancy Act. Suit is not under section 6 of the West Bengal Premises Tenancy Act. Is the suit under section 6 of the West Bengal Premises Tenancy Act? No. Suit has not been filed under section 6 of the on the grounds mentioned under section 6 of the West Bengal Premises Tenancy Act. If that is not so, how 7-1 and 7-2 is maintainable? I'm asking you, Mr. Bhattacharya, if it is not a suit, it's ex facie not maintainable. Page
20.
What is page 24? No. Maybe what is your written?
Yes.
Mr. Bhattacharya, kindly come to section 7. Kindly come to section 7. Kindly come to section 7 once. Don't have the Premises Tenancy Act. এটা দিন। Kindly place the opening sentence of section 7(1). Right hand side, below. Read it loudly. Opening sentence of sections.
By the landlord for eviction on any of the grounds referred to in section 6, the tenant shall
Yes.
be
So if a suit for eviction under section 6 is levied, then only you have a right under section 7(1). So this is not a suit under section 7. This is not a suit under section 6. This is not a suit. Is it a suit under? Mr. Bhattacharya, is it a suit under section 6? If it is not a, Mr. Bhattacharya, it's well settled. There are reported decisions.
Notice has served, notice, but they serve the notice. On the basis of that, you find it,
Mr. Bhattacharya, service of a notice for eviction of a trespasser, for eviction of a lessee under the Transfer of Property Act may have been. But if it is not in that suit, you do not have a right to file 7172.
But I have no right. But when I filed this application, it was court passed the order.
Recalled because other side was not heard. Recalling, let it be now heard on contest. Mr. Bhattacharya, expressly not maintainable. Now, that is, it will be hard on contest. Otherwise, I am of the prima facie view that application is not maintainable. There is a decision, Mr. Bhattacharya, I think of Justice Dibyendu Bhushan Datta. That question arose. It has been held, and this is the opening word of section 7. On a suit being instituted, so section 7 right to file comes only if a suit for eviction under section 6 is instituted. Let it be hard on merits.
Yes, on merits.
On merits, it will be hard. Recalling application has been allowed. Your application is restored. The other side will get an opportunity, thrash it out there. Otherwise, prima facie it is not maintainable.
Prima facie is not maintainable. But the 7(2) is now pending. Yes, your lordship is
It's pending. Let it be decided on merits.
Yes.
I'm not making any observations here.
Yes.
Yes, this application.
$381,001. Suit was filed initially. Controversial, it was transferred before the learned signature Vidhannagar. What happened? Basically, opposite party number 8, he was subsequently purchased of his share of the property from one of the co-sharer. He, after purchase, he purchased in the year 2015. He was added as a party defendant in the year 2021. However, he filed on this suit is for declaration and injunction.
Which suit is for declaration injunction?
That is 381 of
Earlier suit filed by you. That is for declaration and injunction.
What happened after
That is, what is the number? 381 of 2001. Yes.
after purchase, he was added as a party defendant in the year 2021. He filed a suit for declaration and injunction in the court of signatures Barasa. Subsequently, that suit was withdrawn. Thereafter, he filed one application under Order 7 Rule 1 in the present suit in the court of learned signatures at Vidhannagar. Thereafter, he filed another suit for partition before the learned signatures in a petition at Barasa.
Yes.
Thereafter, he filed an application for transfer of the suit 381 of 2001 pending before learned signatures at Vidhannagar to learned signatures third court senior division at Barasa. Learned court allowed that application. Out of it, he has made partly to the section 24 application. Those who are not party of the earlier suit of 2001.
What are the stages of both the suits?
This suit which was transferred and learned court was observed that both the suit may or may not be allowed to hard unanimously. That suit is filed in 2023.
What is the stage? What are the stages of both the suits?
PWs are complete.
In both the suits?
Yes, very recently filed in the year 2023. And during pendency of the Order 7 application lawsuit, suit is transferred. This suit is at the heart of conclusion of the suit.
Title suit number 381 of 2001. That was directed to be withdrawn. By the order impugned.
before
None appears for the petitioner at the time of call. No accommodation has been sought for either. In view thereof, CO 373 of 2025 stands dismissed for default. Next.
I
I'm for the petitioner, my lord. My lord, very innocuous prayer I have. 2018 suit. By some pretext or other, the defendant
What
sometimes
is the stage of the suit?
Lordship, substitution has been done. Now it is fixed for evidence.
SRNAD.
No.
Substitution has been done. It has to be fixed for SRNAD.
Both were there in the record. So the legal heirs were already there on the record. So no other.
So what?
Now it is a stage of evidence.
7th of December 2025 for hearing the vacating ex parte order.
2025.
That is your typed copy. I do not know whether you have correctly typed or
Maybe,
not.
maybe Lordship, it is not correct. It was 24 might be.
7th of February 2025, you have made it 7th of December 2025.
Lordship,
So
it might
7th of February, what happened?
Then vacating has been allowed. We consented for vacating. We
Has been
consented-
allowed.
We consented for everything, Lordship. Now evidence stage. But someday the lawyer is unwell. Someday the
So
defendant.
vacating the ex parte hearing, thereafter written statement has been filed.
Both were already on record. Written statement already filed.
Already filed.
One of them died and substituted. The sole legal heir is already
This
on.
application under Article 2
No, this is a suit for declaration and injunction, madam. Since 2017.
This application under Article 227 of
I pray within a certain period.
no time, you don't know what is the next date, what can be done.
My lord,
Take the account petitioner defendant, my lord, in a suit.
on behalf of the respondent, my lordship, I have filed the vocalet now, my lordship. I am praying for the copy, my lord.
A suit for eviction.
Yes, which order you are challenging, Mr. De?
If your lordship kindly comes to the impugned order, which is
What is the date of the impugned order?
Yes, my lord, it is dated 7 December 2024. My lord, what has happened is, may I narrate the fact before your lordship. My lord, the petitioners were inducted as tenants in respect of 3 rooms, one dining, 1 kitchen on the second floor, and 3 rooms on the roof of the premises in question.
Yes.
Or at the time of induction, an agreement for tenancy was executed. Rupees 15 lakh was given by the petitioners to the landlord as a security deposit. The terms and conditions were that
at the time of induction,
at the time of agreement for when the agreement for tenancy was executed, at that time 15 lakhs was deposited to the landlady.
So you wanted adjustment with the
future rent, not immediately. The rupees 15 lakhs will be with the landlady for 10 years. She will be keeping it in the bank account as a fixed deposit.
That was the agreement.
That was the, I will show it to your lordship. After 10 years, she will return back the 15 lakhs, but the interest accrued thereon will be adjusted from the rent after 10 years. Now, after induction, my lord, I paid rent regularly. After 10 years, I demanded the 15 lakh rupees back. It was denied and disputed. On the other hand, they filed a suit for eviction. I appeared in the said suit, filed section 7.2 application, wherein, my lord, I have denied and disputed the rent as well as the extent of tenancy. Because my tenancy was a composite tenancy for 3 rooms, 1 dining, 1 kitchen on the second floor, and 3 rooms on the roof. Whereas they filed 3 suits splitting my tenancy. I took those points under section 7.2. 7.2 was disposed of. In the first round of 7.2, I relied upon and filed the agreement before the learned court below. The attesting witness was also deposed in the said proceeding before the learned court below. The learned court below came to erroneous conclusion that since the attesting witness is a relative of the petitioner, therefore that evidence will not be looked into and the agreement will not be entertained. I preferred a civil revision before this Honorable Court. Honorable Court allowed my civil revision with giving certain direction as to how the 7.2 application is to be disposed of. That direction, if your lordship kindly comes to page 53, the relevant portion is at page 54.
Yes.
In support of the application, the petitioners produced a witness whose evidence was disbelieved by the trial court solely on the ground that she was a relative of the petitioner and hence an interested party, and as such, her evidence could not be accepted. Now, lordship kindly comes to next page. Page 55, the last para. This is the finding of the Honorable Court. A perusal of the impugned orders in the 3 revisional reveals that the trial court expressly shirked its duty to arrive at even prima facie findings regarding the actual areas due from the defendants to the plaintiffs. Although there was sufficient evidence on record from both sides to arrive at prima facie findings as to the areas of rent, the court below refused to do so on the hypothetical ground that the witness of the defendant's petitioners was a relative and hence was interested, and as such her evidence could not be relied upon. The trial court completely lost sight of the fact that the said witness was apparently a witness in the purported tenancy agreement as well as, and as such could have been a vital witness to prove the attending circumstances. The trial court also refused to exercise jurisdiction vested in it by law in disbelieving the documents of both sides merely on the ground that those were disputed by the respective adversaries. The mere factum of a dispute having been raised without further consideration of the evidence on record could not be ground ipso facto to disbelieve the documents in question. Although the learned advocate for the opposite parties is justified in arguing that the petitioners did not quantify the exact interest accrued from the alleged security deposit in the event such deposit was actually made, and as to whether such interest would have met the arrears of rent, such questions could have been elaborated in the event the parties were permitted to adduce evidence. In the event, the trial court was of the view that the evidence on record was insufficient on that score. Sufficient power is vested with the civil court to direct the parties to adduce further evidence in the event more elaboration is required on a particular point. Now, Lordship kindly comes to the final observation of the Honorable Court, which is very pertinent. However, in view of the rudiments of the pleadings as to required adjustment from the interest accrued from the security deposit being there in the application under Section 7(2) of the 1997 Act and ingredients of such plea being made out in the evidence of the petitioner's witness, the trial court ought to have adverted to the said issue or merits. This was not done by the trial court, thereby vitiating the impugned orders for jurisdictional errors. Therefore, the Honorable Court has specifically directed the learned trial court to look into the evidence, the agreement in particular, and to come to a conclusion. Now, Lordship kindly sees the further observation made by the Honorable Court. Accordingly, the revisional application bearing such and such are allowed on contest, thereby setting aside the orders respectively impugned in each of the said revisional applications and directing the trial court to dispose of afresh the respective applications filed by petitioners under Section 7(2) of the West Bengal Premises Tenancy Act 1997 upon giving fresh opportunity to the parties to adduce evidence if necessary within 15 January 2019. It is made clear that the time frame stipulated herein above is peremptory and the trial court will refuse unnecessary adjournments to both sides to adhere to the said time limit.
What happened after that?
It is further made clear that the application is to be adjudicated on its merit.
Yes.
Now we went back before the learned court below. My lord, we have exhibited the said document, that is the agreement. The learned trial court refused to look into the agreement and to appreciate the contents thereof, although the attesting witness was deposed. Now, Lordship kindly sees the finding of the learned trial court. Learned trial court holds that I am a defaulter without appreciating or giving any kind of credence to the said agreement. The learned court says that agreement will be looked into later on, but now that but I will be adjudicated as a defaulter and I have to make.
Where is that?
Yes. Lordship kindly comes to the internal page of the order, the third page.
Third page.
Yes. The top line.
Yes.
As regard the veracity of the deed of trust, the tenancy agreement dated 5/11/95.
No.
The letter of tenancy dated.
They give me a minute.
Yes, Lordship kindly come
7th of December 2024.
My lord.
Which page?
7/12/2024, Lordship 1, 2, the third page, the last page.
Yes.
On the top, Lordship kindly sees the line starts at the end as.
Yes.
As regard the veracity of the deed of trust, the tenancy agreement dated 5/11/95, which is my sheet anchor. This is my foundation of my case. And letter of tenancy dated 7/11/95 raised by both the sides, it appears that the genuineness of the said documents can be decided during the course of trial after taking evidence on merit. Therefore, the learned court bill has brushed aside the best evidence and has kept the matter pending, although on the other hand has decided that I'm a defaulter. Although I have the attesting witness of the said agreement has deposed before the learned court below in support of my case and has given certain evidence which supports the agreement.
And you have been directed to deposit this
Yes.
57,750.
Yes.
You have not deposited that amount.
Not because I have challenged it before your lordship.
Have you lodged the caveat?
No, my lordship.
Mr. They give her a copy.
My lord, I shall.
Give her what is any 7(3) file?
Yes, my lord. 7(3) has been, if your lordship kindly comes to the first page of the order.
First page of which order?
Of this order itself, because there are 3 suits, because the tenancy has been split into 3. Now, in respect of
First
first
page is
That is at 7/12/2024.
Yes.
Your lordship sees in respect of two suits, my tenancy has my 7/3 has been allowed and my defense has been struck out.
And here only 7/2 has been directed.
7/2 has been directed. I have been directed to deposit the money.
7/3 filed.
Not filed in this matter. Therefore, lordship kindly stays it and lordship kindly
give her a copy.
Yes,
because,
definitely. I shall.
she is appearing.
My lord.
What is the next date? Please.
22nd March. 27 March.
27th March. Ashwin. Yes, when can you come back? Call the next matter.
38, same. All identical matter.
37, 38, 39. 37, 38, 39, same order. Yes, next.
39. 40. No, I'm for the petition.
Yes.
In a suit for declaration, injunction has been rejected. Against that, I made an appeal. In appellate court, local inspection has been held. Report submitted. On the basis of report, my lord, injunction has been granted. Thereafter, suit started, my lord. In the suit, defendant, my lord, file an application. Again, local inspection that has been rejected on that ground. There is a already local inspection has been held. 35 copy was produced. Thereafter, my lord, as my
points are same.
Points are same.
Yes.
My lord, I want to
rightly rejected.
No. Like I have not. Thereafter, I made an. I am the plaintiff petitioner.
Which order you are challenging?
My lord, order number, my lord, last order. My lord, I want to depose the commissioner as witness to prove the my lord local inspection report.
19th of March. Where is that?
My lord, 19th of March. Thereafter, my lord, handwritten, my lord, kindly see. Thereafter, typed copy I have given. My lord, second page. As the local inspection has been held in the said missed appeal case before the appellate court, therefore, unless the until justified reason shown by the plaintiff advocate commissioner, namely Surmishta Das, who held commission work in the miss appeal, cannot be examined in the present suit. Thereafter, I made an appeal application 151 that has been rejected.
Where is your application paying for examination of that commissioner?
For witness, page my lord, 44.
Page 44.
Yes, my lord. Well, record already came to the trial court as per order of the court without any objection of the defendant. I annexed the report.
The local inspection report is before the learned.
Yes, all record has come. My lord, kindly see the page 39. Page 40 is the receipt. Page 40, order, my lord, I have typed out. My lord, page 39, defendant does not raise any objection. Page 40, already, my lord, received the copy, miss appeal.
Give me a minute.
Only to dispute the passage between two houses, my lord. This is the case.
You are the plaintiff or the defendant?
Plaintiff. I am the plaintiff, my lord. The trial court only rejected that This is not a continuation of the suit.
Where is the order of the miscellaneous appeal? Disposing of the miscellaneous appeal.
My lord, page
There
30.
the commissioner's report was considered.
Yes, page 35.
Show me that.
Page 35, my lord.
Show me where the court considered this.
Page 33, last line. Page 33, last line from the local inspection report. Started last
33
line.
Last line.
From the local
Have
inspection
carefully
report.
considered the relevant documents, including the local inspection report and the impugned order.
Next page, my lord. There is 4 feet wide space between the portion of the appellant and the respondent. It is the case of the respondent that 4 feet wide space is being used for the purpose of ingress of the respondent number 1 to the municipal. In this circumstance, definitely respondent will.
You are the respondent number 1 in the appeal.
No.
You are the appellant in the appeal.
Yes.
Did you pray for examination of that commissioner before in the miscellaneous appeal?
No.
Then,
my lord, here, my lord.
Can you now examine? Because that report, because local inspection commission, that report, this
In
was
the-
order 39 rule 7 or order 26 rule 9?
I think order 39 rule 7, my lord.
Order 39 rule 7 or order 26 rule 9?
Order 39 rule 7, my lord, that is even another at page 36 that has been rejected. Same application.
No, I'm asking you.
Yes,
the,
miss appeal,
what
miss
was,
appeal.
that was under order 39 rule 7 or order 26 rule 9? You have the copy of the order by which it was allowed.
That has been annexed, my lord.
Whether it is order 39 rule 7 or order 26 rule 9.
My lord, page 29.
Page 29.
Yes. Local inspection, my lord. Page 29, order sheet, my lord. Appeal court's order. July 18, 2009. Appellant local inspection petition such and such is taken up hearing.
So why did you not apply for examining that commissioner before in the miscellaneous appeal? Miscellaneous appeal that was rejected.
That has not been done, my lord. My lord, kindly come to page 36 once. Court rejected the defendant's application on that ground only. Page 36.
Yes. What is page 36?
Page 36, this is the application order 39 rule 7 filed by the defendant. My lord, ordering courts, I have perused my lord, last 3 paragraphs.
Yes.
I have perused the local inspection report such and such date, certified copy of which has been filed in court, the report reveals that the defendant number one and law clerk of his advocate were present during the commissioner, but they refused to put their signature on the notice and the field note of the learned advocate commissioner. Be that as it may, the report clearly indicates the length.
So the certified copy has been filed.
Thereafter, it has been.
You are not the defendant. Their player for local inspection was rejected.
No, what is the ground? Already in view of the same, I am of view that instant petition for local does not merit acceptance.
Because there is already a report on the same points.
Yes, that's
certified copy is there.
Thereafter, record has been come before the trial court.
Yes.
On page number 40.
No, that's subsequently, but the defendant has filed the certified
court says
copy.
that already it has been done. That's why time has. I am not on that.
You did not examine the commissioner
before the appeal court.
You took advantage of that. Now you want to cross-examine.
No, only prove the. I am not only prove the. My lord, the report before the court below.
That certified copy has been filed. That will be marked as an exhibit.
My lord, that's maybe direct.
That is already there.
Record also produced before the court. I am not against the report, my lord. I am not against the report. My lord, page 40 record received by the trial court. Page 40.
Yes, because you prayed for examination. That was only rejected. You did not pray for that marking of the exhibit.
No. I am
19th of March. Kindly come to the order. You wanted the commissioner to be examined.
Yes.
That was rejected. Certified copy of the report is already there.
Kindly page 45, the prayer portion of my application.
Yes, for adducing evidence.
Yes.
So
to prove the, I am not against
the. You did not challenge that in the miscellaneous appeal.
I am not against the report, my lord. I am not against the report.
So you want that report to be exhibited. That is already there. For that examination is not necessary. Certified copy is there.
Kindly only clarify this, my lord.
This application under Article 227 of the Constitution of India
Lordship, I am for the petitioner.
What do you want?
Lordship, expedition, matter for
Hearing
expedition.
of what? Title appeal.
Yes, Lordship.
This application under Article 227 of the Constitution of India is at the instance of the appellant. You are the appellant
Yes.
or the
No,
respondent?
I am respondent.
Is at
I'm
the instance of the respondent in title appeal number
in
1322 of 2014, praying for a direction upon the learned additional district judge, 5th court at Howrah, to dispose of the title appeal expeditiously. What is the stage of the appeal?
Lordship, appeal hearing is going on, and the appellants are filing one or the other applications and dealing.
What is the last order?
Last order, Lordship? In the last order, Lordship, appellant had filed an application under Order 1, Rule 10(2) of the CPC for addition of parties, who were already there in the plaint at the.
What happened to this application under Order 1, Rule 10(2)?
Lordship, already we had, if you see, before that we had already filed the amended. Already.
Order 1, Rule 10 allowed?
Yes, Lordship. Already, because they were already in the suit. The parties were already in the suit.
Order 1, Rule 10 in the appeal allowed?
Allowed.
It appears from the order dated 17th of May 2023.
Lordship, hearing expeditiously.
Yes, yes, next.
Got 42, I have instructions to appear on behalf of Acre, the Assets Reconstruction Company.
So I'll give him notice.
Order passed by the DRT.
Notice, he's appearing, notice.
I'm appearing.
How this revision is maintainable, Mr. Bose?
But he's appearing, he wants notice.
Son of appeal, Mr. Bose.
I can understand, but my lord, I'll tell you, Lordship, if I can cross the hurdle of alternative remedy, then
Alternative remedy, the Supreme Court, after considering that
Supreme Court is, my lord, those, my lord, I shouldn't, I'm not in a position to say that, but this alternative remedy issue has all along, my lord, in the last judgment in Godrej thoroughly, Justice Dotto has held that this is a self-restraint, judicial restraint, but there is no law that if there is a alternative remedy, the court cannot exercise its authority under Article 226 or 227, so to
Lies
say.
with the
Of course, of course, of course. The discretion is always there. If your lordship applies the discretion and say that I will not apply my discretion in the facts of this case, that's different. Complete, self-restraint.
it's not that, because you are aware of those line of decisions which says in respect of the SARFAESI and other matters, so high courts should refrain from, that is the exact word, even after taking to the judgments wherein these exceptions have been carved out, considering that in the next paragraph it has been said, but in this type of matters, 226 and 227.
And then matters which has gone up also, Supreme Court has entertained. Well, there is one matter which I argued before Justice Shampa Sarkar from an order passed by the National Company Law Tribunal. So there is also a statutory appeal before the NCLAT. Similarly, like Debt Recovery Tribunal to DRAT.
You must be also aware of the decision of the Honorable Supreme Court wherein naming certain high courts, it has been said these high courts are repeatedly interfering in SARFAESI matters. You are aware of those decisions?
We are.
High courts have been named in the order.
We are one of them.
No, thankfully we are not one of them.
Not as yet.
We are not in that decision, but some high courts have been named.
But the only difficulty is that I've got a very good case on merit. Now, the only difficulty is that if you
take those points in the appeal also, I will.
The only difficulty, I'll tell you, Lordship, my lord, this is an order. The order of the Debt Recovery Tribunal is on 9th of January 2025. The statutory period of appeal is 30 days.
9th of January 2025.
2025.
When have you filed this application?
This civil
22nd of January.
Yes.
So this period will be.
And anyway, Section 5 applies before appeals.
Section 5, 14.
No,
all these
14.
You can take that one. 14 has to be there. You can take the benefit of this.
18F5 apply kore na.
It applies. 17, Section 5 might not apply, but there's the contra judgments even by the Orissa High Court, even a couple of weeks back.
But 14 will apply.
14 will apply.
14.
And so far
That's what I'm saying. So,
Section 18 appeal is concerned, Section 5 applies.
Well, if then he says that he will not oppose the Section 5, I have not. I would rather take benefit of 14 than take recourse to 5, because the statute doesn't refer to 5.
I'm not saying anything.
My lord, yes, your lordship says since there is a alternative efficacious remedy, then your lordship will not entertain it on that ground. Then we
yes. I will be only saying that, not on merits.
Very.
What is the order under challenge?
Well, order under challenge is 9 January 2000, by which a Section 14 order, well, there was a pending SARFAESI appeal under steps measures under Section 13.
I only need to.
Well, the certified copy at the last annexure to the revision.
Which volume?
Third volume.
Third volume.
Civil revision. And when I filed 2 volumes, my loss.
Unnecessary orders have been, unnecessary. There was no reason. They have annexed the entire essay application.
And you are also not saying anything with regard to that. You are also accepting this.
Accepting what?
This type of 3 volume.
No.
Not saying anything to the advocate.
By the time it came, it was already in 3 volume by the time it filed. So it shouldn't have, it was not necessary. If your lordship will see.
Told your advocate.
Absolutely.
So that in the next matter, this will not be done.
Absolutely.
Hope so.
Absolutely.
Then in the next matter, which Mr. Bose will appear, these 3 volumes will not come.
No, certainly not. Revisional application jurisdiction is limited.
This application under Article 227 of the Constitution of India is at the instance Yes.
My lord, in 43, I have challenged the last order. It is the consequential order to other. My lord, here the petitioner is the Chittaranjan Locomotive Works, Government of India.
Yes.
My lord, one contract employee filed an application before the Central Government Industrial Tribunal, and since the date of application, filing of such application, she never appeared. My lord, the question is, my lord, the presiding officer is asking everyone being the party, my lord, page 56, to file a written statement. My lord, when Union of India has already filed the written statement, Lordship kindly see the order dated 27th of March, where my lord, in the
27th of March 2024.
Yes, last paragraph, both parties have filed their written statement, hence let the case be fixed up for evidence for workman. After filing of such, my lord, this last order, my lord, 22nd 11/2024, whereby, my lord, the presiding officer is asking everyone, because the interest is same, my lord, all the respondents on behalf of Union of India, the application has been filed. Now he is asking to file fresh Fokalotnama for each respondent. And my lord, this is the order.
According to you, you do not wish to file any written statement. I will record that and direct the tribunal to proceed in accordance with law.
Yes. Well,
I will record that you do not wish to file any written
that is
statement.
true. Lord. The question is,
Because
Lord, I have
Union of
already.
India is a different thing altogether, because allegation is against you. So you are the employer.
I am the employer.
So you are the employer.
Yes.
If the employer chooses not to file any written statement, I will record that.
That is their domain, my lord. They will file. They have already filed.
No, Chittaranjan Locomotive has not filed.
Yes. The written statements have been filed. My lord, Lordship, and both parties have filed their written statement.
Chittaranjan Locomotive has filed.
Yes. Lordship, kindly see the order dated 27/3.
None of them has filed any written statement. General manager, general manager and the Chittaranjan Locomotive Works has filed, but general manager and chief personnel manager has not filed.
My lord, the interest is.
So I shall record that. It's not necessary. Chittaranjan Locomotive Works has filed a written statement.
Yes.
Ashun.
And that is the order.
Your Lordship, in item number 44, I am applying for the petitioner. I am praying for not today, Your Lordship.
Why?
Your Lordship, I am led by Mr. Subhashish Gupta. He is in, he's traveling. So, Your Lordship, kindly take the matter tomorrow.
An accommodation has been paid for. Adjourned. Next.
Hi.
My lord, in item number 45, I appear for the caveat opposite party.
The caveat has been filed, petition has been filed on 20th. We have filed the caveat.
Subsequently,
20th,
we have.
But our petition has been filed on second. This is the difference. After filing our petition, they have filed caveat.
Yes, they have, you have received the.
Lordship,
What is the impugned order?
Lordship, in this matter, Lordship, Mr. Ramakrishna Bhattacharya is appearing.
Please use the microphone.
In this matter, Lordship, Mr. Ramakrishna Bhattacharya is appearing. His daughter's marriage, so that he could not come to the court. My humble submission before your Lordship, let the matter be appeared after 7th of this month.
A
copy may be served.
The learned advocate appearing for the petitioner prays for an accommodation. On the ground of the learned advocate on record? No, on the ground of Mr.
The ground is Michel, because
on the ground of his learned senior.
Senior.
Stop. What is your name?
My name is Pulak
Dipto Banerjee.
Yes, caveat has been lodged by the
20th salary. Have
you served him a copy, Mr. Dipto Banerjee? Have you served him a copy?
Lordship,
the learned advocate appearing for the petitioner.
Filed the caveat 20.
The learned advocate appearing for the caveat submits that no copy of this application under Article 227 of the Constitution of India has been served upon him. From the endorsement made, it appears that a caveat was lodged by Mr. Dipto Banerjee on 12th of December 2024.
Lordship,
petitioner is directed to serve a copy of this application.
22, sir. 22, 2024.
Sir, I am directing you to serve. You are paying for an accommodation. Please serve.
Lordship.
The learned advocate for the petitioner is directed to serve a copy of this application.
My lord, in a suit for preemption under section 8 and 9 of WBLR Act, my lord, an application for amendment of plaint was filed by the plaintiff.
Yes.
But that is not under, my lord, under order 6 rule 17, but under section 151 of the Code of Civil Procedure, my lord.
In the trial court, my lord, I have already submitted the objection to the said application in the ground that when there is a specific remedy, court cannot invoke section 151 of the code of civil procedure, as there is a
Amendment has been allowed.
Amendment has been allowed, my lord. Challenging the same, my lord, I came before your lordship.
Yes.
My only humble submission, my lord, there is a specific remedy under Order 6, Rule 17. My lord, court cannot invoke, my lord, section 151 anytime, my lord, in any case. But only thing, my lord, there are several opposite parties, my lord. Only one opposite party has filed the caveat. I have served only one opposite party, my lord. In this respect, my lord, I want to refer to judgments before your lordship passed by the honorable.
There is a specific provision in the code 151.
151, my lord.
Should not be resorted.
Should not be resorted to, my lord.
That is well settled principle.
My lord.
For that you need not cite any decisions.
My only humble submission is that, my lord.
If you want, you can cite.
My lord.
Right. Where is the application for?
My lord, the application.
Amendment, where is that?
My lord. This is, my lord, CO number 443 of 2000.
No, which page is the application for amendment?
My lord, my lord, page number 55 of CO number 443 of 2025, my lord. Page number 55 is the application for amendment. Annexure D.
So according to you, it ought to have been filed under Order 6, Rule 17.
It ought to have been filed under Order 6, Rule 17. Identical, my lord.
Same. Next is same.
Same, my lord, only the miscase number will be changed.
Miscase number, date of the order.
Date of the order is also same, my lord.
Date is also, তাহলে miscase number টা দেখে নেবেন শুধু। Next matter টা, same order.
Grateful.
Next. Miscase number টা, order এর date টা একটু দেখে 49, yes.
For the petitioner, my lord. Well, I'm praying for not this week.
Why?
But Mr. Shubhamoy Patro is appearing in this matter.
Who is appearing?
Mr. Shubhamoy Patro, he is the advocate on record.
Yes.
I was just informed by his clerk that he has fallen ill. I'm praying for not this week.
You are not appearing.
No, my lord.
Then don't pray for upgradation. An accommodation has been prayed for on the
Fifty, my lord, I appeal for the petitioner.
Yes.
This is my application directed against rejection of my application under Order 7, Rule 11. I'm the defendant in a suit. My main ground, lordship, was number one, the plaintiff has played fraud upon the court. The plaintiff had initially filed a title suit on the self-same cause of action, failed to obtain an interim order of injunction, failed to obtain an order whereby commissioner is to be appointed, which came up to the Honorable High Court, and it was held that the commissioner could not be appointed because it would amount to fishing of evidence. Because they failed to get any specific relief in the previous suit, they filed another suit during pendency of the previous suit, almost on identical prayers. I took out an application under Order 7, Rule 11, and that has been rejected, lordship.
So that suit is pending.
That suit is pending.
Yes.
But they are not taking any steps there. They have completely suppressed the fact that a previous suit has been filed. And also that the interim order prayer for injunction, injunction has also been refused. Nothing has been disclosed. And both the suits are almost on identical prayers.
If we are bound under Order 7, Rule 11.
Illusive.
Clause you are invoking.
Lordship kindly comes to page
No,
20
which
of
of the clause under Order 7, Rule 11?
They have not sought for leave under Order 2, Rule 2 of the CPC. And lordship kindly sees the prayers once. Kindly comes to page 20.
Yes.
I'm just reading out the prayer, my lord. Decree of declaration that plaintiffs are joint bona fide tenants, page 20 of my application, 20.
Page 20.
Yes, lordship.
Yes.
For a decree of declaration that the plaintiffs are joint bona fide tenants of the Schedule A flat under the defendant and entitled to enjoy tenancy of Schedule A of the flat.
What is the other earlier suit? Or the other suit?
Yes, lordship. This is now, lordship kindly comes to page 35.
35.
35. And lordship kindly takes note that they have not sought for leave under Order 2, Rule 2.
Why Order 2, Rule 2 is necessary?
Because it's on the between the same parties, same cause of action, and the same premises. They have just added one extra declaration, that to a negative one, in the subsequent suit.
Is it necessary that in all suits leave under Order 2, Rule 2 is to be
in the same,
if the plaintiff does not want to sue it afterwards?
but the
No leave is
cause of action is
up to the-
absolutely identical, my lord.
up to the plaintiff.
It is absolutely identical.
For that, the suit cannot be said to be barred.
Kindly sees the prayers that we have made.
For that, the suit cannot be said to be barred.
And if I've taken up the point of suppression and fraud,
That cannot be decided in Order 7, Rule 11. How can that be decided? It has to be on a bare reading of the plaint.
Plaint.
So in the evidence, have you filed your written statement?
No, I'm
File your
yet,
written statement, took all these.
I have filed an application under Order 39 Rule 4, but it should be nipped in the bud, my humble submission, because it's a frivolous suit that they have filed.
That cannot be gone into now.
Then
at
kindly,
this stage.
kindly permits me to take out an application under 151 urging the point of suppression and that may be
Already there,
taken
why
up.
liberty is necessary?
Because the learned trial judge has already taken up those points and the plaintiffs will again stand in the way saying that this has already been decided, this is res judicata.
No, where is this? Where
But
is,
Lordship,
show me
kindly,
what has
kindly,
been decided?
Lordship, kindly comes to page 4 of the impugned order.
Yes,
The last paragraph.
yes,
May I just place?
yes, yes.
Having regard to the submission of both the parties and carefully going through the documents submitted by the defendant with the application filed under Order 7 Rule 11, it appears to me that between the self-same parties, another suit is pending, but the prayer of both the suits and also cause of action are not similar. I humbly disagree with this. Though in the instant suit, it has been argued by the defendant that an illusory cause of action has been shown in the present suit, and by clever drafting, when the present suit has been filed, suppressing the pendency of the earlier suit of similar nature, but from plain reading of the present plaint as well as the plaint of the earlier suit, it has not been found that the cause of action and the prayer for both the suit are same.
Where is the other
Lordship,
suit?
the other suit, Lordship, and it comes to the present suit is at page 17 and the
Yes.
previous suit is at page 35.
35.
Yes,
Start.
Lordship. It starts at 35. The prayer is at page 38, my lord.
Where is that page 38?
38. Kindly sees the prayer and compares it with the subsequent suit's prayer. Nearly identical.
No.
Lordship, kindly sees decree of declaration that defendant has no right to encroach the easement rights to the plaintiff's
Yes.
annex to the tenancy.
Yes. Entirely different.
And kindly
You
comes
certain towers
the same
rightly
thing.
held.
Both of them is for the towers.
No.
And the prayer that they have sought for.
In this suit, where is that? Towers have
Lordship.
not.
Yes, Lordship, kindly. Kindly comes to page 21.
Yes.
Kindly reads, I mean, I've just placed prayer B for a decree of permanent injunction restraining the defendant from disturbing peaceful possession as well as easement right attached to the tenancy. So that is on the tenanted premises. It is the area adjoining the roof on which they have no tenancy right. I want to install a tower. I have taken necessary permissions. They are trying to come in the way of that. They had filed the initial suit because of that. Kindly see the next prayer. For a further decree of permanent injunction restraining the defendant and his men from making any illegal construction work of structure on the
Assuming
vacant
that
land.
both the suits prayers are same, is it barred under the law? Show me under what provision it is barred. Let us assume for the time being your argument to be correct. Self-same reliefs, 2 suits have been filed between the self-same parties. Is it barred under the law? Which law bars it?
It's one extra prayer that they have made in the subsequent suit. There should
Let us
have been
assume
only-
all are same.
Hmm.
Where is the bar in the law that 2 suits for the same reliefs cannot be filed?
But the second one has an illusory cause of action. Only because they failed to obtain an injunction
Where
in
is
the
the bar?
previous one.
Which law bars that? You are trying to invoke Order 7, Rule 11D, bar of law. Which law bars this? The one which is disposed of, if the issues are same, the other will be barred by res judicata. So, there is no bar for institution and for. So, trial may be bar, you can apply under section 10. Those are there. So, that is why section 10 is there.
Yeah.
Section 11 is there. Unless it is decided, section 11 cannot come into play. Yes.
Then I may be granted leave to take appropriate steps in accordance
That
with
is
law. This should
already
not
there.
stand in the way of my.
This application under Article
My lord, I'm appearing for the petition, my lord, praying for not today. Praying for not today, my lord.
Why?
My lord, the advocate on record is engaged in Alipur court, my lord, for that.
An accommodation has been paid for by the learned advocate. You are appearing. None appears for the petitioner at the time of call. No accommodation has been sought for either. CO number 448 of 2025 stands dismissed for default. Next.
53. A shoot for preemption. Very interesting, I tell your lordship.
Interesting.
Very interesting.
What is the interesting
Why I
point?
tell your lordship? Shoot for preemption. First, in the opposite party, purchaser was made a party. Purchaser was made a party in the shoot for preemption. Co-sharer was not made a party. Subsequently,
I could not follow your submission.
shoot for preemption. Now the co-sharer, my co-sharer sold it to a stranger purchaser, outsider. That outsider was made a respondent in the original suit. My co-sharer was not made a party.
According to you, the vendor was
Vendor
not implemented.
Not implemented.
Is the vendor a necessary party
I
in
tell
an
you,
application under our section 8
not
and
required, not required. I tell you, lordship. Subsequently, what happened? Subsequently, both the vendor, seller, and purchaser colluded and filed a suit whereby the deed was made void. They entered into a declaration that they do not want to make any claim any right over the purchase deed. Subsequently, the same vendor sold it to the seller's wife. Same property, only the price was made different within 3 months from the date of the collusive deed, compromise deed. I filed an application on Order 1 Rule 10.2 to bring on record the subsequent purchaser, that is the wife of the earlier seller, earlier wife of the earlier purchaser, and an application Order 6 Rule 17.
Earlier purchaser or the subsequent purchaser?
Both. Earlier purchaser as well as the subsequent purchaser, because first deed was made null and void by the degree of compromise.
Yes. First, you filed an application for preemption.
Filed an application for preemption.
So the vendor and the purchaser, or the preemptee and his vendor. So in a suit, they entered into a compromise.
And the compromise.
So that
decree
that deed was held to be null and void.
Null and
Declared
void.
null and void in a compromise decree. Thereafter, that vendor or your co-sharer, he transferred to the preemptee's
wife. On the same property.
Yes.
Only the difference is the money consideration difference was made. Now I filed an application for addition of party to the
preemption application.
In that preemption application.
Is it maintainable?
And secondly,
is it maintainable?
But to that extent, my first argument will be that the schedule of the property is same.
Maybe.
Schedule
but the
is
transaction, because the transaction, what you are trying to preempt is the first transfer or the second transfer?
Second transfer. Because first transfer got null and void by the degree of compromise.
So you have to challenge the second transfer.
Yeah, I have to.
So you have to put in the consideration of the second transfer.
But second transfer,
that is an independent application. That will be an independent application under section 8 and 9.
My respective submission is
what happened? Your order 1 rule 10 rejected.
Rejected. My order.
Rightly rejected.
Order 6 rule 7.
I have not seen the order. After hearing you, rightly rejected. What is the reasoning?
Reasoning is that you will have to set aside the compromise degree in the said suit where the compromise has been entered into. That I cannot do because I am not a party to the proceeding.
May not be. But if you want the subsequent sale, you want to preempt, you have to file a fresh preemption application.
But that fresh preemption
addition will not help.
But that fresh preemption.
Because what will be done? So what is the effect of this preemption? So the right, title and interest of that person, your preemptee, will vest in you. So by virtue of that deed, see, that deed is not challenged. Merely by addition, you cannot get anything.
No, not only by addition, but since the property schedule of the property remains the same.
But the deed is not the same.
Deed is not the same. So
have you seen the judgment? I think of which court I forgot.
To that extent, I made an
effect is erasing the name of the purchaser in that deed and putting the name of this preemptor That is the effect of an order of preemption. Very beautiful judgment. So only in the deed, the name of the purchaser will be erased, in his place, the preemptor's name. So that is the effect. So unless you challenge that deed, you have to pay for preemption of that subsequent deed.
But by that time, my lord, the limitation will come into effect.
Has come, cannot be helped.
But the
After all, now the Supreme Court has said it's a weak right, though a statutory right.
preemption is always a weak right. Preemption is always a weak right, but still
You accept that. So
No,
more so I'm accepting your submission and passing this. It's a weak right.
May I just indicate to lordship, but the whole difficulty lies in that I have put in the entire consideration money for so far as the earlier deed is concerned. That is already on record. Now
You are
subsequently,
at liberty to withdraw that.
subsequent
You are at liberty to withdraw that.
yes, that liberty is there. My subsequent is that, but the by the time I will be challenging, putting a challenge under section 8 and 9, that there were limitation is there. Unless the order 6 rule 17 has been allowed, my
order 6 rule 17 amendment.
Amendment to the extent bringing on record the new deed.
Cannot be done. Cannot be done.
Since the schedule of the property remains the same.
Cannot be done. What is the effect of allowing an application for amendment? It will relate back to the date of filing of the. So at that point of time, this deed was not in existence. The deed which is impugned was not in existence. Once this amendment is allowed, it will relate back to the filing of the suit. At that point of time, this deed was not in existence also. Either way, Mr. Basu will be not trapped.
I'm in a difficult position. I accept it. And the collusive suit has created the menace. They have colluded together. They allowed the deed to go in within 3 months from the date of the degree of the collusive suit. The vendor sold it to the seller's wife. And that is the reason why I brought an application under order 6 rule 17, indicating the entire thing. Only substitution is that the deed number.
Second deed is also a sale deed.
Sale deed.
They ought to have couched it in a different form. That is the mistake which they have done.
The second deed,
I am not saying it openly now.
Sale deed, only the consideration has been.
Now we are online. Someone may be watching.
What they have cunningly done, they have increased the consideration.
Not very cunningly done. They could have done more cunningly.
My right has been jeopardized. Section 8, subsequent deed, bar. Now I cannot agitate this point unless there is a comprehensive amendment being done. And in my application for addition of party, I intend to make both the X and Y and Y1, the husband and the subsequent purchaser, as a party to the proceeding.
Where is your application?
My application to order 6 rule 17 at page 66. And addition of party is page 65.
So first is addition.
First is addition. Both
Otherwise,
were hard together. Both were hard together.
Unless addition, how amendment?
Addition is mechanism page 65. The underlying portion. The entire facts are narrated in a very nutshell. Now, the husband and the wife, the Abdul Razak Mullah and the Firdaus Begum. Abdul Razak Mullah is the purchaser of the first deed, and Firdaus Bibi is my wife, is the wife of the purchaser, who is the purchaser in the second deed. It is a collusive suit to the extent both husband and wife both are involved.
Once that earlier deed goes, your preemption application goes.
Now, what they have done by taking advantage of this rigors of the law, they have colluded together to.
Yes, Mr. Ghosh. What is the legal effect of this? A preemption application has been filed. Now what happened, the vendor of the preemptee at the preemptee, they, in a suit filed by the vendor of the preemptee, compromise decree was entered into. That deed was declared to be null and void.
Yes.
Now that vendor
Yes.
has transferred to the wife of the PMT.
Yeah.
Now he wants that wife to be added
Yeah.
in the earlier preemption proceeding. Once that deed goes, this preemption application, what remains in the preemption application?
Nothing but he can make an application suit for declaration that is.
That is a different thing altogether.
But similar
preemption
circumstances-
application goes. If he wants to, he can. He has a right to
Yes.
file a fresh preemption of the subsequent transfer, but cannot be added.
That can be done. Other or not the similar circumstance in the similar circumstances earlier occasion, Lord, the after getting the notice of preemption application, there was an exchange. So
That
he
is
made
why
this suit-
I avoided that expression.
Yes.
So you are saying cunningly, I said not very cunningly.
Yes.
Could have been more cunning. You are,
to find that
that has not been done.
time has
Could have been a transfer which falls within the exceptions of 8.2. Gone.
exchange.
By the time
That
No,
was, Mr. Ghosh said that. I kept mum on that. I did not open that. I did not say that. 8.2 exceptions, you are gone.
now by this time, my lord, my right also goes evaporates because there is a limitation.
When you file this application under Order 1 Rule 10, that was within time. You could have.
Page 65. May I just indicate to your lordship? It was perhaps filed.
And if it is out of time, then also cannot be added because it's time barred. Either way, you are
My lord,
trapped,
the
Mr. Basu.
2024.
When was the transfer?
July 2024.
When was the transfer?
Was December 2022.
Gone. Also time barred. In that way also gone. Could not have been allowed. Party could not have been allowed added after the limitation has been set up. In all way, you are gone. All roads are blocked. No way to go out.
But my right goes.
Cannot be helped. Now let me see the reasoning, what the learned trial judge has said. No, this is all compromise. Where is the addition?
My lord, so far as addition is concerned, my lord, nothing has been said. Only thing is that compromise has been entered into. You file a fresh suit or apply before the court who has passed the degree.
Rightly. When no relief can be granted for the impugned deed having been declared void consequent, the addition will not help. The ultimate conclusion is right.
But my lord, in my respective submission, my lord, the statutory right by a collusive degree has been taken away. The collusive degree which has been entered into, a lawful right which has
You challenge that degree.
But I am not a proceeding, I am not a party to the deed itself.
There are procedures, even if you are not a party.
Yes, yes.
You have to advise your client accordingly.
Yes, there are procedures.
Ashun. This application under Article 227 of the Constitution of India is at the instance of the preemptor in mispreemption case number 45 of 2021 and is directed against an order being
But I'm being led by Mr. Aniruddha Mitra, my lord. I'm being led by Mr. Aniruddha Mitra, my lord, learned senior advocate. And my lord, for deciding this revision, my lord, the service will also be necessary, my lord. If my lord can't.
Service without admission, no direction for service.
Very well, my lord.
What is the impugned order?
My lord, the impugned order is of 4th of April 2022, my lord.
An accommodation has been prayed for on the ground of the learned senior counsel for the petitioner. As prayed for, the hearing of the matter stands adjourned.
I'm grateful.
Yeah, for the petitioner. There is a caveat on our sir.
Yes.
I'm saying for not today, man.
Why?
For this matter, I am led by Mr. Pintu Kadar. He's out of. In this matter, I am led by Mr. Pintu Kadar. He's out of court due to the personal duty.
My application under Order 7 Rule.
Not today.
Application under Order 6 Rule 17.
Order 7 Rule 11, my lord, has been rejected by the learned trial judge, my lord. I am for the, my lord, dependent number 1.
Order 6. What is the
Order
impugned
7
order?
Order 7. Impugned order page 35, my lord. Lord, my
Order dated 11th of December 2024.
No, my lord. Page 35, my lord.
Page 35. There is no page 35. CO 452 of 2025.
451, my lord.
451. কোনটা দিলেন এটা?
55.
হ্যাঁ 451 তো 452 টা দিলেন তো। সরি। Yes.
Impugned order is at page 35, my lord. Order 7, Rule 11 of the CPC has been rejected, my lord. I am for the, my lord, dependent number 1, my lord. The opposite party on 1 is the plaintiff, my lord. He has filed one suit for partition and for permanent injunction. Against that, we have filed this application for rejection of plaint.
What is the ground in Order 7 Rule 11?
The ground, my lord, I have stated in, my lord, kindly see page 31 is the, my lord, petition, my lord, page 31, my lord, under Order 7 Rule 11, my lord. My lord, already there is a partition deed, my lord. In the year 1969, the deed has been executed. This suit plot has already been, my lord, partitioned, my lord. In spite of that, they are admitted in their plaint that they are in possession of the, my lord, the plot in question for which they have been, my lord, allotted their, my lord, share, my lord. In spite of that, they have not filed this partition suit. You know, kindly come, I have annexed the plaint, my lord. Page 27, my lord, page, my lord.
Yes.
Page 27, my lord. This is the plate, my lord.
Yes.
Lord, kindly see, my lord.
So they have admitted the fact of the partition deed
Yes,
of 1969.
1969.
But was it partitioned by meets and bounds?
Yes, my lord. Partition. Yes, my lord.
Show me that they have admitted that it was partitioned by meets and bounds. Where is the deed?
The deed I have not annexed, but I have annexed the plaint, my lord. Page 27, they have admitted in their plaint that.
Show me that admission.
Can you see page 27, my lord?
Page 27? Yes.
My lord. Last but one paragraph, এক্ষণে, my lord.
Yes.
এক্ষণে আপোষ সমস্যা মতে এই বাদীগণ পূর্ব দিকে 11 ফুট চওড়া দোকানঘর দখলিকার আছেন। নালিশি সম্পত্তিতে এই বাদী তাহার অংশ মোতাবেক সত্যবান ও দখলিকার আছেন। But
No. The deed of 1969, where it is been admitted.
Yes, but they have admitted in their plain.
Show me that admission, deed of 1969.
My lord, page 24, my lord.
24, yes.
Middle portion, middle, that partition দলিল মূলে উক্ত সম্পত্তি partition করিয়া লয়েন। My lord, that is the দাগের জমি লইয়া গত ইংরাজি 14/12/69 তারিখে 7677 নম্বর partition দলিল মূলে উক্ত সম্পত্তি partition করিয়া লয়েন। Got it, my lord?
Shares have been declared.
Shares are declared.
But
yes.
Partition by meets and bounds was not made.
But that is not
That is
their,
the thing.
but
So
that
it has to be decided in the time of trial.
that is not their case is that malad we are malad forcefully encroach a portion of their property malad.
Yes.
But they have malad
So
stated
that
in-
cannot be decided in Order 7 Rule 11. According to you, this partition suit is not maintainable as the property was partitioned in 1969. They have admitted
Yes.
that shares were only declared. It was not partitioned by meets
But
and
malad,
bounds.
learned trial has not allowed me to file any objection against this malad application.
What objection?
But they have not.
That is your application and Order
my
7 Rule 11.
application, they have not given me opportunity to file their objection. On the same date when we have
It is
filed
not
this
needed.
application,
Objection is not needed. Application is also not needed. Suo moto court can reject the claim if you can show. Ashun, this application under Article 227 of the Constitution of India is at the instance of the defendant. Number
Item number 56 on behalf of Mr. Asif Dewan, praying for only days accommodation.
An accommodation has been prayed for on the ground of the learned advocate for
My lord, I am for the petitioner, my lord, section 24, application for transferring of the matrimonial suit from learned.
Where to where?
My lord, Asansol to Bishnupur, my lord. My lord, section 125 maintenance application is pending at Bishnupur, and also, my lord, criminal case under 498A and allied sections are pending there.
All are pending at Bishnupur.
My lord.
This application under section 24 of the Code of Civil Procedure is at the
or not.
Why the
Because
right to sue does not survive?
the licensee,
Licensee, eviction of a licensee.
my lord, the plaintiff suit is for declaration that they are perpetual licensee. The plaintiff expired. And only difficulty is that today they have served another application which I want to bring on record before this court, my lord. Lordship will allow me to file a supplementary affidavit in this.
As prayed for by the learned advocate for the petitioner, leave is granted to the '60. Yes.
It is expeditious disposal.
What of what?
The suit itself. Suit
Suit.
itself.
What is the stage of the suit? What is the stage of the suit?
Framing of suit. Framing of issue.
Framing of issues.
Yes. Next date is the 7th March.
For what?
For framing of issue, and it is continuing for last 6 months.
7th of March for framing of issues.
Yes, and it is continuing for last 6 months in the same stage. And previously there is a coordinate bench decision for concluding the all interlocutory application within 3 months. It was takes for 3 years.
This application under Article 227 of the Constitution of India.
For the petitioner, Lord, there is a suit for declaration that plaintiff is entitled to get terminal benefits due to death of her father. Lord, the only predicament is, Lord, judgment has been passed.
What judgment has been passed?
Lord,
suit.
Yes, my lord. The suit was dismissed. I was a plaintiff in the matter. This is a judgment.
Then you have to challenge.
Lord, only my lord,
227,
prayer
nothing can
is,
be done.
my lord, I'm seeking a leave under 105.
That is already there. Ashun. This application under Article 227 of the Constitution of India.
appearing for the opposite party. The petitioner herein is a very, I should not use any wrong words, but he's
What have I done?
Lordship, I am not aware. I just entered and the matter was over. There are at least
Expeditious.
23 to 24 applications, proceedings that he has already filed against the, it's a Nico House property actually. So
I've only directed the suit to be disposed of expeditiously. I have not passed any order.
Lordship, this required some hearing, Lordship, at least. Because
I've only directed the suit to be disposed of expeditiously. I have not passed any other order. How will we be affected by an order directing expeditious hearing of the suit? Then it shows that you are trying to delay the hearing of
no,
the suit.
Lordship, it is not a question of delaying the suit.
I've
Lordship.
not passed any order. I've only directed, look to the order. I've only directed, he said that date has been fixed for framing of the issues.
Lordship.
So I've only directed the Taito. Framing of the issues, I've only directed the suit to be disposed of expeditiously without granting any unnecessary adjournments. I have not decided the rights of the parties.
Lordship, is it possible to record my submission?
What?
Regarding that, I was actually praying for a copy of the civil division and also
That I have directed them to serve a copy.
Lordship.
Application along with this order.
Lordship.
That direction is already there.
The matter will be returnable.
Matter has been disposed of.
With your lordships, kindly
I'm
may
grateful,
permitted to mention item number 52 has been dismissed for default by your lordship. If your lordship may kindly direct the matter to be restored, lordship.
Why? We are not there.
Lordship, we are in court number 26, lordship. We are just rushing. The matter has been called
Item number
into
52.
52, lordship.
What is item number 52? Yes.
In item number 60, can I just put my name appearing for the opposite parties?
What is the application?
The revisional application is that initially a suit has been filed by the petitioner for praying for declaration and injunction in respect
What is the impugned order?
Impugned order is of rejection of that application on the rejection of my suit on the ground of res judicata, lordship.
Suit dismissed.
Suit has been dismissed on the ground of
You have
res
a copy
judicata.
of the application with you.
Lordship.
Where is your brief? You are coming to restore the application. It has been dismissed. Where is your brief? Where is your copy of the application?
Lordship, I have the petition in
soft copy.
Soft copy. Only the application, lordship, without annexures.
Show me. Do you have the impugned order there?
No, lordship. No.
How you will argue with that soft copy?
Your lordship may kindly take up this matter tomorrow, lordship. I will try to satisfy your lordship. Tomorrow, lordship, if
the suit has been dismissed.
Suit has been dismissed, lordship, on the ground of res judicata. Our contention is that we have filed a suit. Their contention is that a previous suit has been filed in respect of the same self property and the same self cause of action. In the previous suit, that is title suit number 76 of 2011,
the suit has been dismissed on the ground of res judicata.
Ground of res judicata.
So how the revision is maintainable? You have to challenge that in an appeal if the suit has been dismissed.
Lordship, it is maintainable.
52 ta Calcutta to be mentioned again.
Lordship, I am grateful.
ওটাকে বলে দেবেন তাহলে dismissal order.
Grateful.